More about the Supreme Court now with this discussion of the legacy of former Justice Lewis Powell. We'll hear about a landmark 1972 decision on the rights of reporters. Washington and Lee University hosted this event in honor of the 100th anniversary of Justice Powell's birth. It's about 3 hours.
Okay, I'd like to call this session to order, please, if I may. My name's Louise Halper. My name's Louise Halper. I'm the director of the Francis Lewis Law Center. We're met here on the 100th anniversary of the birth of Justice Lewis Powell, our distinguished alumnus and a most distinguished Supreme Court justice, who is responsible for a good deal of the jurisprudential landscape of our era. Our symposium today, in his honor, concerns freedom of the press, and in particular, whether the Constitution allows a reporter to shield the identity of sources. And here, Justice Powell's decisive but ambiguous and maybe ambivalent concurrence in Branzburg is the center of our inquiry. So without much more ado, I'd like to say that we're going to have words of welcome from Dean Smola and President Ruscio, and from Lewis Powell III, the son of Lewis Powell Jr., and a distinguished attorney in his own right who's also an alumnus of Washington and Lee University. We'll then open the proceedings with the first panel, of which Brian Murchison, professor of law here at Washington and Lee, is the moderator, and he'll introduce the panelists. After the first panel and a break, Professor Dayo Abba, a professor of journalism at Washington and Lee, will introduce and moderate panel 2. So let me now call on Dean Smola to say just a few words. Thank you.
Thanks, Louise. Welcome to the greater Lexington metropolitan area, and welcome to Washington and Lee University. I want to express particular thanks to Justice Powell's son and daughter, Louis and Josephine, who are here with us with other members of the Powell family to celebrate the legacy of this great and influential American and Supreme Court justice. We have a wonderful group of panelists with us today to share their insights into Justice Powell and into the relationship between a journalist and his or her sources. And we are all looking forward to hearing their remarks. And I'll now ask President Ruscio to come and express some welcome on behalf of Washington and Lee.
Well, thank you, Rod. And to those of you unfamiliar with Lexington, you should know that every day is like today. Kathleen, I know you come from a different part of the country where you think you have perfect weather, but this is exactly how every day is here in Lexington. We just don't want that many people to know about it. I really just want to make a couple of comments by way of welcome and about the nature of your discussion here today. Justice Powell for Washington and Lee is, of course, a revered and respected alumnus. And Washington and Lee as a university thrives on its narratives. It thrives on its stories. And often, to sort of simplify those stories, to kind of capture the essence of those stories, we reflect upon certain distinguished individuals associated with us. And Justice Powell is, of course, one of those. But there are certain people, like Justice Powell, who find themselves getting into a different category in our narratives. And it's not just that he embodies all of the values and all of the ideals that we think Washington and Lee stands for. He is in that rare category of an individual who, by his life and by his example, we come to try to emulate him. It's that he influences our institution as much as we like to think we influenced him. He shapes us today by virtue of his life and his accomplishments. One of those that I'd like to at least highlight is it's a personal one for me. and it's the nature of civil and reasoned disagreement. I think sometimes, as Dean Smolla last night talked about how Justice Powell fills the middle in legal and political debates, he kind of demonstrates the strength of moderation and reason. And sometimes that gets mistaken, not so much in his case, but sometimes in other samples, as kind of the muddled middle, kind of the compromise route, kind of the splitting the difference route. But civility and civil disagreement and reasoned disagreement can also be exactly the opposite of that. It can be the embracing of disagreement and entering the realm of disagreement with the confidence that you can come out of it, not just with your respect for your opponent intact, but actually your respect for your opponent enhanced. And Justice Powell certainly, to me, demonstrated those values and certainly stands as an example, I think, for all of us in that way. So in that spirit, I wish you today a lot of great disagreement, a lot of spirited disagreement, with the knowledge that at the end of the day, you'll leave here not just with your respect for each other intact, but actually greatly enhanced. So I wish you well, and welcome to the symposium.
President Ruscio, Dean Smolla, distinguished panelists, ladies and gentlemen, good morning. I'm very pleased on behalf of my family to say good morning and to welcome you to this symposium. I spent a little time this morning as I was running up the road to collect Mr. Comey reflecting on what Dad might think of this gathering. I think he would be at the same time both embarrassed about the attention directed in his way and at the same time gratified that Washington and Lee would continue to play a role in shaping the contours of a debate that is ever more important today than it was when he participated in the Branzburg decision. I spoke a little bit last night about his arrival here in Lexington in September of 1925. I thought a little bit more about that this morning. You know, mid-1920s, the country was just off the heels of the war to end all wars, and on the cusp of what became the three defining challenges of his generation, none of which I expect anyone could have anticipated in the mid-1920s. One economic, one military, and one ideological. His generation, what Tom Brokaw came to call the greatest generation, handled them all: the Great Depression, World War II, and the Cold War, those challenges stretching out over the balance of the century. It occurred to me that 6 years and 6 days ago from today, all of us awoke on September 11, not imagining the challenge that would face our generation, which began that day and will extend, no doubt, some say, for decades, which is all at once wrapped up in one single unitary challenge that is economic, military, and ideological. How we deal with that challenge, both outside the boundaries of the country and, for purposes of our discussion today, inside the country, how we resolve the tensions between the branches of government, the three that are named in the Constitution, and the fourth branch, which is essential to the exercise of our democratic freedoms. How we resolve those tensions internally will say a great deal about who we are and why we wage the fight. I asked for the opportunity to speak a little bit this morning, not only on behalf of my family, but also because I know David Weston and Jim Comey and Chuck Rosenberg, and it's been my privilege to count the three of them as friends. David, at the helm of ABC News, has a great deal to do with the way a very important element of the Fourth Estate does its job. I think anyone who's followed history lately understands the role of a free and vigorous and courageous press in making sure that the government keeps its skirts clean. At the same time, inside the senior ranks of the Justice Department, for those of you who've been paying attention to the media lately, know that Jim Comey as Deputy Attorney General and Chuck Rosenberg as Jim's Chief of Staff were at the center of a firestorm that happened in a hospital room on March the 10th, 2004, the details of which only recently began to emerge. Were it not for courageous public servants willing to stand up for what they believe to be true, willing to go toe-to-toe with the President of the United States in a time of national crisis, I think history would not look back kindly on how we conducted the war, at least in these early stages. But Jim Comey and Chuck Rosenberg and Bob Mueller and others were in the right place at the right time. And when the full verdict of history is rendered on how the war on terror was waged internally, and when we know the full story, I think we'll be even more proud of them than we already are. Chuck, of course, now continues to wage the fight as the United States Attorney for the Eastern District of Virginia, which is the venue of choice for terror prosecutions. Jim has taken what I hope will be a short recess from public service, and he is General Counsel of Lockheed Martin, where he's very much involved, obviously, in the generation of some of the tools with which we fight. David, as president of ABC News, sends friends and reporters in harm's way. Many of you will remember his brand new World News Tonight co-anchor, Bob Woodruff, was nearly killed in Iraq in January of 2006, within weeks of having been named co-anchor of the evening news. We have Mike Allen, we have Kathleen Sullivan, we have two very distinguished panels. All of these people are deeply engaged in the debate about how we go forward as lawyers and as public servants and as news people in a time of national crisis where there are legitimate tensions between the interests of national security, the interest of the First Amendment, the interest of the Fourth Amendment. Having discussions such as this, discussions that, as President Ruscio reminds us, need to be conducted civilly even though disagreements may be deeply held, is very important. And I'm very pleased to have had the opportunity to play a small role in the formation of this. Washington and Lee does my family and my father a great honor by conducting this event on the 100th anniversary of his birth. And I have been looking forward to the discussion this morning with these very fine panelists for some time. And without further ado, I will yield the floor to Brian Murchison.
Morning, I'm Brian Murchison. I'm a member of the law faculty. It's my pleasure this morning to introduce the members of our first panel. Before I do, let me just recognize that we have a number of very welcome visitors here today, and I'm thinking of Tom and Shelley Milheiser in the front row who helped make this beautiful room possible for the law school. It remains the heart and soul of this building, and we welcome you all here today. Also, Charlie and Lee Rowe are here with us today. Charlie's a former newspaperman, editor, publisher in Virginia. He is a great friend of Washington and Lee and has supported our programs in law and journalism for a long time. So it's great to have Charlie and Lee with us as well. Now let me introduce the members of the panel. Kathleen M. Sullivan is one of the country's preeminent scholars and teachers of constitutional law, was named by the National Law Journal as one of the 100 most influential lawyers in America. She has written leading case books on constitutional law and on the First Amendment, and is an outstanding litigator who has argued before numerous courts of appeals and the U.S. Supreme Court. She joined the Stanford Law faculty in 1993 after teaching at Harvard Law School for a number of years. From 1999 to 2004, Professor Sullivan served as the 11th Dean of Stanford Law School and the first woman dean of any school at Stanford. Her record as a dean is extraordinary. She made numerous faculty appointments, established the clinical faculty there, launched academic centers, started the LLM program, raised many millions of dollars for the school. She has a BA degree from Cornell, was a Marshall Scholar at Oxford. She received her JD from Harvard. She is an elected fellow of the American Academy of Arts and Sciences and of the American Philosophical Society. She's known to students at Washington and Lee as the author of a brief in the U.S. Supreme Court that we study in the first year. So I really welcome you to Washington and Lee today. Our second panelist is Rod Smolla, the new dean of Washington and Lee Law School, himself an outstanding First Amendment scholar. His book, entitled Free Speech in an Open Society, won the William O. Douglas Award in 1992 as the year's best monograph on freedom of expression. His book, Suing the Press, Libel, the Media, and Power, won the ABA Silver Gavel Award Certificate of Merit in 1986. He's the author of 3 treatises, Smolla and Nimmer on freedom of speech, federal civil rights acts, and the law of defamation. He's also the author of a case book on the First Amendment and co-author of a case book on constitutional law. He's a well-known advocate in cases involving civil rights and mass media. He's argued cases at every level, including the Supreme Court of the United States. He's a graduate of Yale College and Duke Law School. He was formerly dean of the law school at the University of Richmond, and before that, he was director of the Bill of Rights Institute at William & Mary. And in a very short period of time, he's become an indispensable member of the W&L law family. So it's great to have him on this panel. And to his right is James B. Comey, currently General Counsel and Senior Vice President of Lockheed Martin. He was Deputy Attorney General of the United States, serving in that position from December 2003 through August 2005. He was then the second highest ranking official in the Justice Department and ran the day-to-day operations of the department. In that position, he appointed Patrick Fitzgerald, the U.S. Attorney in Chicago, as special counsel to head the Valerie Plame leak grand jury investigation. Mr. Comey served as U.S. Attorney for the Southern District of New York for 2 years before being appointed Deputy Attorney General. As U.S. Attorney, he oversaw numerous terrorism cases. He supervised prosecutions of executives of WorldCom, Adelphia, other entities in fraud and securities-related charges. He created a specialized unit to prosecute international drug cartels. From 1996 to 2001, he was managing assistant U.S. attorney in charge of the Richmond Division of the U.S. Attorney's Office for the Eastern District of Virginia. He's a graduate of William & Mary, holds a law degree from the University of Chicago. He was law clerk for U.S. District Court Judge John M. Walker, Jr. While in Richmond, he also served as an adjunct professor at the University of Richmond Law School. We will proceed as follows. Dean Smolla will get things started by addressing the case of Branzburg versus Hayes, that 1972 Supreme Court decision on reporters' privilege, in which Justice Powell concurred with the majority, yet wrote what has been called the enigmatic concurrence. After Dean Smolla reflects on Branzburg, Dean Sullivan will consider the aftermath of Branzburg and its forward march to present day, with reference to current arguments and cases in which journalist privilege is a central issue. Then Mr. Comey will round things off with his reflections from the perspective of a former federal prosecutor in investigations dealing with national security and the availability or lack thereof of evidence from journalists. So Dean Smolla, will you come on up?
Thank you, Brian, and good morning again, everyone. Not far from where we are at this moment, in a climate-controlled room in the library of the law school here, are the papers of Justice Powell. And I brought with me for you to see the files in 2 of his cases that dealt with the intersection of law and journalism. The first is his file in the Branzburg case. Here it is. And The second is his file in another very famous case involving the First Amendment, a case called Gertz versus Robert Welch involving defamation law and the levels of fault that apply when either public figures or private figures sue the press or a publisher for libel. The Gertz case is another of Justice Powell's masterpieces, and here's the file in that case. Now, I thought it would be interesting to compare the two for a number of reasons. First, for what they reveal about the character and the judicial deportment and temperament and thought processes of Justice Powell. And second, for what they reveal about the relationship between journalists and their sources. In comparing the two cases, it's first interesting to reflect on their similarities. As several people have mentioned, including President Ruscio, Justice Powell was often the person in the middle. In that sense, he was a mediator between the more liberal wing and the more conservative wing of the court at his time, and he occupied a position not unlike that which would later be occupied by his friend, Justice Sandra Day O'Connor, and occupied today by Justice Anthony Kennedy. But as President Ruscio suggested, there's more to it than just being the person in the middle. Because what I think you will hear throughout the morning is that Justice Powell had a penchant for genuinely appreciating and understanding and internalizing the validity of conflicting constitutional values and conflicting constitutional arguments. And so he wasn't simply a weak compromiser, but he was more a creative resolver who sought to look for resolutions that would balance the interests at stake. You see that in these two opinions, and you see it throughout his jurisprudence. Probably most famously, not with regard to the First Amendment, but with regard to equality, to race and gender discrimination. Perhaps his most famous opinion, of course, is his opinion in the Bakke case, in which he at once rejected the claim of the University of California at Davis that it could employ a quota system in order to achieve racial diversity and ethnic diversity, but at the same time approved of the notions of universities in the pursuit of diversity in higher education engaging in race-conscious measures. You see it in his jurisprudence in gender equality in a very famous case called Frontiero versus Richardson, in which the issue was discrimination between male and female members of the armed services. There were a group of justices who wanted to equate gender discrimination with race discrimination and apply a very high level of constitutional scrutiny to gender discrimination, essentially identical to the way in which we treat race. And there were a group of justices who did not want to do that, and Justice Powell ended up occupying a middle ground, arguing for an intermediate level of scrutiny. And that remains today the law of the land. Itself also connected here to Lexington, Virginia, because the test announced in the Frontiero case would be the test subsequently applied by the Supreme Court of the United States in United States versus Virginia, in which our neighboring university, VMI, was forced by our federal courts to co-educate. Now, the other characteristic that is very powerful in Justice Powell's jurisprudence throughout his cases is that his rulings often seem to invite subsequent conversation, subsequent democratic experimentation by the states and by the Congress, and subsequent judicial elaboration. This was a common characteristic. And so if you think of the Bakke case, there would be decades and decades of ferment over the role of race-conscious measures to achieve diversity in higher education. Federal courts would split on the meaning of Bakke and on the role of Justice Powell's opinion. Ultimately, the Supreme Court of the United States in the University of Michigan cases would follow the roadmap that he said in a decision that approved of the race-conscious measures at the law school, but not at the undergraduate school, and Justice O'Connor would embrace the values of Justice Powell there. But the democratic conversation would continue, and states such as California and Michigan and Texas would ultimately, through political action, reject the concept of affirmative action that the Supreme Court and Justice Powell seemed to approve. In the two cases that I want to talk to us a bit about, you see that. In the Gertz case, Justice Powell said that the two conflicting constitutional values are, first, the obvious value in a robust press reporting on national affairs, and second, the countervailing social value in the protection of individual reputation and human dignity. And the compromise that he struck was a rule that provided a very high level of First Amendment protection when the person suing for libel was a public figure or a public official, but a lower level of protection when the person suing for libel was a private figure. In the Gertz case, however, Justice Powell said that this was simply the First Amendment floor, and that states were free, if they chose, to elaborate on that and to add protections beyond that. And a number of states, a handful of states, including New York, a very important state for media purposes, did adopt higher standards for private figure cases. If those are some of the similarities between Branzburg and Gertz, what are the differences? I'll hold the two opinions up again for you to see. Gertz is a much thicker file than Branzburg. Gertz is an elaborate, well thought out, comprehensive solution to the problem of public figures and private figures and the reconciliation of the value of reputation and the First Amendment. Gertz is a finished thought. It reads almost like the restatement of torts. It is an elaborate matrix of rules, not only dealing with the public figure-private figure dichotomy, but many other elements of damages and fault in defamation law and its intersection with the First Amendment. It is a complete body of work, it is a finished product, and it has proved remarkably stable. Although there have been elaborations on Gertz and tinkering with it on the margins, it has been a guideline that has existed essentially without controversy for nearly 3 decades, and hundreds of courts have decided cases under Gertz and interpreted it, and it is not in play in current constitutional law or for the most part in our public discourse. It is a settled matter. Branzburg, on the other hand, is an incomplete thought. It's only a few pages long in his notes, and his opinion for the court is but a few paragraphs long. And I don't think that Justice Powell reached real resolution in the Branzburg case. I don't think he was able, in his own mind, to complete the project in the way that he did in Gertz. And so the interesting question is, why might that be? I'm going to suggest to you that Justice Powell, as revealed in his notes on the case, felt very, very acutely the power of the conflicting forces that are at large when we deal with the question of whether a journalist should be able to keep his or her source confidential from a judicial inquiry, either at the grand jury level or in a trial. And in his own mind, I do not believe that those conflicts were reconciled. And that's one of the reasons that lower courts have split over the meaning of Branzburg, and that's one of the reasons that it continues to be hotly contested in our political and cultural debates. So what are the conflicts? There really are two. On the side of journalists, there is, of course, the notion that the protection of the confidentiality of one's source goes to the heart of the news-gathering process, and we have a more robust search for truth on the part of journalists if they are able to grant to a source a promise of confidentiality that is judicially enforceable. What are on the opposite side of the argument in Branzburg? Two constitutional values. The first constitutional value is nothing less than our commitment to the rule of law. There's first the surface notion that is part of the heart of all of our law, that no person is above the law. When a journalist says, although most people in society would be forced to swear on an oath to tell the truth, the whole truth, and nothing but the truth, and reveal the evidence that they know, a journalist, when a journalist asserts the privilege, is claiming, in a sense, to be above that, to be exempt from that. That is, of course, always the case when, in a trial or in any judicial proceeding, a person invokes a privilege and claims as a matter of right that they do not have to give the evidence that other citizens would be required to give. Indeed, it's helpful to think about the connection between executive privilege and the journalist's privilege. On a certain level, they are both the same claim. And in United States versus Nixon, the famous executive privilege case, you may remember that the pervasive theme in the opinion for the court in that case is the notion that it is sacred in our country that no person is above the law, not even the President of the United States. And even the President of the United States may be required to answer to judicial process, and although there should be an executive privilege, that privilege can be overcome by a court that decides that the compelling need for the judicial branch to ferret out the truth trumps the value of that privilege as an expression of the importance of the executive and the importance of the executive having candid conversations with his or her advisors. In the journalist's case, much the same dynamic is arguably at work. Yet in our law, we often do grant privileges. We often do say that because of the nature of a relationship or because of larger social values that are at stake, we will not require that someone give evidence in a court of law as they would otherwise be required to do. Usually, that involves a combination of a special relationship that the speakers had with one another that society decides is especially worthy of encouraging. And so there are privileges for the husband and the wife in marriage. There are privileges for the attorney and the client. There are privileges for the priest and the penitent, for the psychiatrist and the patient. There is a privilege for the President of the United States and his or her close, intimate advisors, in part because we want to strengthen that bond and strengthen that relationship. Parallel to that is the notion that as part of that relationship, we want to encourage candor. We want those people to be able to talk fluidly and exchange information between them, and we don't want the fear that what they say to one another, or even their identity at times, may later be brought into public scrutiny. Now, in the case of a journalist, there isn't the special bond quality. That is to say, the relationship between a journalist and a source doesn't have that fiduciary quality, that pre-existing relationship quality that you see in some of the other instances. But it does have going for it the very powerful notion that we grant the privilege because it is very important for a larger public to hear the information that the journalist wishes to report on, and to encourage the flow of information from the source to the journalist, we allow for the privilege. So in the last few minutes, I want to cross-examine that claim a little more deeply and test it against two things. First, whether it is a strong empirical case, whether in our experience we really believe that the judicial recognition of the privilege is essential to encouraging robust news gathering. And secondly, the dilemma that we are faced with if we grant the privilege because it invites us apparently to discriminate among different kinds of speakers and different kinds of news gatherers, something that is particularly acute today in the modern age of the internet and blogging. Let's first just think for a few moments about the empirical case. Is it true that promises of confidentiality to sources encourage and facilitate news gathering and the free flow of information in our society? It seems to me self-evidently obvious the answer must be yes. Of course that is the case. Every day throughout the country, hundreds of stories appear in newspapers and broadcast media, on the internet, in which a pivotal piece of the story is based on information from an unnamed source or a confidential source. If you watch CNN for 3 or 4 hours this evening, or the ABC News broadcast, you will likely today see a story or 2 or 3 in which an unnamed source is pivotal with regard to the story, all right? But that's not the entire question, because the question is not whether it is important for journalists to be able to promise confidentiality. The question is whether it's important for a court to later honor that when it is tested in a judicial proceeding. And this, here I think the case is more ambivalent. First of all, recognize that in only a minuscule percentage of cases will the promise of confidentiality ever even reach any judicial forum. Today there may be hundreds of stories in print in which there are confidential sources. The odds are that in none of them will there ever be a judicial proceeding in which the journalist will be asked to testify. In fact, the probability is that out of the thousands and thousands and thousands of promises of confidentiality in any given year, a handful ever result in a journalist being brought before a grand jury or brought before any sort of investigation in which the journalist is asked to reveal the source. And so that forces us to ask, what is it that's being promised when the journalist says, yes, this is on background, yes, I promise I will not reveal your name? Is it that the journalist is saying, I won't use your name in the story? Period. The journalist might not be saying, but, and if later asked by a prosecutor to reveal your name or by a judge to reveal your name, I will invoke a privilege and try to resist revealing your name. But is it also true that the journalist is saying, I will go to jail for you? I will engage in civil disobedience. I will place myself, if you will, beyond the law or above the law. And even when our judicial processes say that the privilege doesn't exist or has been overcome, I will hold the line and refuse to divulge your name. It seems to me a bit unclear as to whether that is actually part of the promise. Is the promise, I will go to jail, or is the promise, I will do all that I can within our legal structure to avoid revealing your name? But if there comes a point at which the ordinary processes of law say the privilege ought to give way to the need for every person's evidence, at that point, I will not be a journalist, I will be a citizen, and I will obey the rule of law, and I will give up your name. It's unclear, but you can see that if it's the second of those sorts of promises, one could make the argument that in fact nothing will be lost, nothing much will be lost if there is no judicial recognition of a journalist's privilege, because overwhelmingly journalists will grant promises of confidentiality. Overwhelmingly it'll never be tested, and in the cases in which it is tested, it doesn't matter in a sense whether the privilege is judicially honored or not, because that wasn't the promise that the source and the journalist were thinking of at the time of the original transaction. The second problem, which I've already alluded to, is that if you grant journalists a privilege, you must decide what a journalist is. This is a headache in terms of First Amendment theory, because for the most part, we have resisted in First Amendment law picking and choosing among speakers. Indeed, in the Branzburg case, one of the themes was whether the press clause would have independent meaning that supplied a special protection for the institutional press different from the protections of the speech clause, which provide protection to ordinary citizens. And for the most part, our Supreme Court has refused to pick and choose. It has refused to breathe special meaning into the press clause, and it generally says that it violates the First Amendment to pick and choose among speakers. And so, if one of you in the room, not a member of the institutional press, were to interview someone for some sort of activity that you wish to engage in, some expressive activity that you wish to engage in, and if one of our visitors from C-SPAN today, a member of the institutional press, of course, were to make the same promise to the same person, if there is a reporter's privilege, arguably, the members of the official press would get the benefit of that privilege, but the amateurs would not, all right? And this offends our sense of sort of an egalitarian First Amendment. Obviously, this is made far more intense given the emergence of the blogosphere and the role of amateur journalism as an enormously important engine in our public discourse today, in which we have largely broken down the concept that there even is such a thing as a world of professional journalism, clearly distinct from the other forms of sort of public participation journalism with which we all engage. Last point, I'll close with this. I said to you that Justice Powell's opinions often invited subsequent democratic discourse. And in this case, with regard to reporters' privilege, what has happened in that subsequent discourse is striking. Although the Supreme Court of the United States appeared to reject the existence of a First Amendment privilege in Branzburg, and I will tell you, if you come up afterwards and look through these notes, you will see in Justice Powell's handwriting numerous times underscored no First Amendment privilege. So it's difficult looking at his notes to interpret the case as if it, in fact, was intended to create a privilege. Even though the Supreme Court rejected that view, as Kathleen, I'm sure, will tell us, many lower courts relying on the Powell opinion said, either as a matter of First Amendment law or as a matter of federal common law, a privilege did exist in the federal system. That was particularly true in the early years following Branzburg. The tide has turned, and there have been many influential lower court opinions. Of course, the most important recently, the Judith Miller litigation, in which the claim that Branzburg creates a privilege has been rejected. Even so, the democratic dialogue and the judicial evolution dialogue has continued. And today, 49 states and the District of Columbia recognize some form of reporter's privilege. They have either enacted legislation creating a shield law, usually a qualified privilege, in some states an absolute privilege for confidential information, or as a matter of state common law or state constitutional law, some form of privilege has been recognized. Now that is an interesting exercise in reverse federalism. You know that Justice Louis Brandeis said that the states should be laboratories for experiment. And to the extent that the states have been laboratories for experiment on this issue, it would appear that the results are in. There's been a kind of collective democratic plebiscite, and there is an overwhelming consensus, it appears, that it is valuable to society to favor the truth-seeking engine of the press and the free flow of information over the truth-seeking information of our courts and the pursuit of the rule of law, at least by balancing the two, at least by giving journalists a threshold right to claim the confidentiality which a court may or may not later override. There is now, of course, a great debate going on in Congress over whether there should be a federal shield law. Because if the First Amendment cannot be counted on as the source of such a law as a matter of constitutional law, obviously Congress could do what the states have done and create some form of shield law. My own view is that such a law should be adopted, and that the balance that has been struck by the states is the appropriate balance. I'm sure our panelists in this panel and in the next panel will elaborate on some of the conflicting policy issues, but a very quick roadmap as to what I think ought to emerge, though I doubt any of this will emerge. I think there ought to be a shield law, but I don't think it ought to be absolute. Just as executive privilege is not absolute, I think that the journalist's privilege should not be absolute, and a court should be permitted to weigh the conflicting values. The privilege should apply broadly, beyond the institutional press to anyone who is engaged in the functional equivalent of news gathering and dissemination to a mass audience. And so a blogger in his or her room using his or her computer to ferret out information is entitled to the privilege every bit as much as a reporter for the New York Times if they are engaged in the functional equivalent of news gathering. As many courts have recognized, the privilege ought not be a have your cake and eat it too matter, and this means that at least in civil litigation, in, for example, defamation cases, if a journalist relies on a source for a story, and if the object of the story sues for defamation, and if the journalist says, I am innocent of actual malice, I am innocent of fault here because I had a source, the plaintiff may then ask, well, who was your source? How do we know there was a source? How do we know you didn't make the source up? The journalist may be able to invoke the privilege, and indeed a court may honor the privilege, but then the journalist ought not be entitled to rely on the existence of the source to prove the absence of malice. And there are a number of state court decisions, importantly in New York, that say that that is the trade-off that is appropriate. If you wish to retain the confidentiality of your source, you can't have your cake and eat it too and say, oh, I've got a source, therefore I'm not guilty of actual malice, that you've got to make that decision. Finally, the question that has tended to be the issue on which our society has hung up, particularly since 9/11, which Lewis Powell alluded to, is the question of whether there should be a per se national security carve-out for the assertion of the source. Actually, thinking back to United States versus Nixon, you may remember there are suggestions in the case that the executive privilege, if invoked by the president in a national security matter, might be absolute, might not be something that could be overridden by a court. It's never been resolved again by the Supreme Court of the United States. But there are many in Congress who would say that the reporter's privilege should always give way if what is being reported on touches on matters of national security. I think this is profoundly wrong and exactly the opposite societal value. Because if anything has been proven, including by the brave actions of some of the people on the panel today that you will hear from, it is that when matters of national security are at stake, it is enormously important, it is particularly important that there be a robust Fourth Estate engaged in news gathering as a check and balance on the executive branch and on the political branches. And so there ought not be a blanket exception for national security. There ought instead be a case-by-case balancing of the competing interests. Thanks.
Good morning, ladies and gentlemen. President Ruscio, Dean Smola, members of the Powell family, and Washington and Lee community, it is a great honor to be part of this symposium in honor of the great Justice Lewis Powell. And I'd like to tell a story in three parts, picking up where Dean Smola left off. Justice Powell's First Amendment. Let's begin with the first part, Justice Powell's First Amendment, as illustrated by his oracular concurrence in Branzburg versus Hayes. Second, the era when, despite its brevity, as Dean Smola already suggested, that opinion ruled in the lower courts over the words of the plurality opinion. And the third act is the retrenchment from Justice Powell's First Amendment in the recent era. And I'm going to ask what has changed, and then I'm going to ask the question, what would Justice Powell say if we could parachute him into the current environment and ask him to analyze Reporter's Shield against the backdrop of current events? Now, to begin with, Justice Powell's First Amendment, as exemplified by his concurrence in Branzburg versus Hayes, I want to suggest to you that it had three features of his jurisprudence. Dean Smola has already alluded to this, but first is a solicitude for the original Bill of Rights, a solicitude for the First Amendment that's exemplified in his words when he says the court does not hold. He tries to say the plurality, although it denies a privilege for reporters who had reported on hashish making and bomb plots discussed by a Black Panther meeting. He said, although the privilege doesn't apply to the reporters who reported on those stories and then refused to testify before a grand jury, even if they could keep the identity of their sources confidential, He says, I'm going to provide the fifth vote to hold that they do not get to have an absolute privilege against grand jury testimony. I'm going to agree with Justice White and the 4 justices in the plurality on that point. But, and here's his solicitude for the First Amendment, his concurrence opens, the court does not hold that newsmen subpoenaed to testify before a grand jury are without constitutional rights with respect to the gathering of news or in safeguarding their sources. The solicitude repeatedly shown by this court for First Amendment freedoms should be sufficient assurance against any such effort. I'm not saying this in the mellifluous Virginian with which he would have said it, but I hope you'll understand it anyway. Second feature besides solicitude for the First Amendment was balancing, as Dean Smolla has already suggested. The approach, the methodological approach of balancing. He says the asserted claim to privilege should be judged on its facts by the striking of a proper balance between freedom of the press and the obligation of all citizens to give relevant testimony with respect to criminal conduct. That kind of balancing was absolutely typical of his decisions in other areas, whether it was in the Bakke concurrence, another 5-4 concurrence that determined a generation of institutional practices, in which he said quotas on the basis of race are not a sufficient safeguard of the guarantee of equal protection, but taking race into account as a factor to remedy past sins of discrimination or to provide diversity in the people we graduate from the nation's colleges, that's okay, that kind of balancing of interests. And third, it exemplifies his case-by-case approach. He said the balance of these vital constitutional and societal interests on a case-by-case basis accords with the tried and traditional way of adjudicating such questions. So it would matter to Justice Powell whether on the facts the government was harassing the press. You might remember that Governor Huey Long once imposed a special tax on a newspaper over a certain size, and when asked why he'd imposed it, he imposed it on a newspaper that had been somewhat critical of his governing practices. And he said, oh, it's a tax on lying. So we have a longstanding First Amendment tradition that says that when government actually singles out the press for special punishment or persecution, that's not going to be allowed. So Justice Powell cared about the facts. Was the government acting in good faith? He cared about relevance. He said government shouldn't be allowed to go after a grand jury subpoena that has only remote and tenuous relationship to the subject of the investigation. And he spoke about the legitimate needs of law enforcement. All right, so 3 features: a solicitude for the First Amendment, a balancing approach that acknowledged governmental need, but wanted to look at that need case by case. And that resonates absolutely with his other opinions, Bakke, or the opinion in Plyler versus Doe, on which you'll hear an eloquent lecture by Linda Greenhouse this coming Wednesday, when he said that the right to education is so important that you can't exclude undocumented alien children who were here by no fault of their own absolutely from the schools, even if there was no right to an equal education in terms of redistributing finances. So case by case. Now, I've speculated why did Justice Powell have that particular combination of attitudes? Where did his solicitude for the press come from? What drove him to go to all the trouble, even if the file is slim, to file that special concurrence in Branzburg versus Hayes? And I reflected on his life, the magnificent life in the law that's reflected in his work as a corporate lawyer, as chairman for a decade of the Richmond School Board, as president of the American Bar Association after tenure on local bar associations. And I thought, well, he must have known a great deal about the press in those capacities, of its power and its foibles. He must have known how to deal with the press for good and the dangers of the press for interference with the work he was trying to do on behalf of his clients, on behalf of the school board, on behalf of the bar. And I speculated that Justice Powell was someone who believed in a kind of tacit backdrop to the First Amendment. You know, we all have tacit assumptions about constitutional rights. They're so given that we don't even think about them. And we have a right to be secure in our papers, houses, and effects. We need warrants and knock and announce before the police come through our door. Well, we assume we have a reasonable expectation of privacy because we tacitly assume we don't live in glass houses, that a house is a place that's shielded from the view of the world. Well, similarly, I think behind the First Amendment, I think Justice Powell may have had a tacit assumption that the relevant elites here would behave responsibly with institutional self-restraint. On the one hand, the press would exercise self-restraint so that when it really needed to go underground into a Black Panther meeting, a hashish factory, a Klan meeting in the woods and get a confidential source to report a story, then and only then would it rely on confidential sources, only when it could get the information only by secrecy. At the same time, I imagine that Justice Powell, having worked with many prosecutors on the other side of corporate issues in his time, believed in the self-restraint of the federal prosecutors and state prosecutors who might subpoena those reporters, a view that they wouldn't go after the reporters unless they'd exhausted every other lead, given every other investigative opportunity, come to the press last. And you see that Justice Powell is thinking this way when he writes in his Branzburg concurrence that you should not read this opinion to allow the government to annex the press as an investigative arm of the government. So I imagine him trusting in the self-restraint of well-meaning elites, prosecutors on the one hand, the institutional press on the other hand. And this trust in the leadership of our societal institutions is evident elsewhere in his opinions. When he speaks of the self-restraint that college admissions officers will exercise under his opinion in Bakke, he's imagining that there will be internal self-restraint, self-governing rules of conduct that can be trusted to create, in this context, a kind of gentleman's agreement. Government will only come after you for your sources if they really need it. You will only rely on confidential sources if you really need them. I ventured to suggest this interpretation to Lewis Powell III and asked whether it resonated at all with his sense of his father, and he said I wasn't completely out of line, that this trust and institutional self-restraint was perhaps a feature of his father's view of the world based on his participation in those important leadership roles. So if we take Justice Powell's First Amendment, we have to close that chapter by saying he believed that there would be a self-regulating system operating through mutual self-restraint. Now let's go to Chapter 2, the period from 1972 until our recent era, when Justice Powell's concurrence in Branzburg versus Hayes really did become the law of the land, even though it was a concurrence. And technically, it was needed to decide the case. There were 4 dissenters who vigorously thought the privilege should have prevented the subpoena from being executed against the reporters in that case. So in order to decide the case in favor of the privilege, it's a canon of construction of a Supreme Court divided opinion that the vote needed to create the narrowest ruling is the one that's decisive, and here that was Justice Powell's. And for several decades, his concurrence was taken as the law. There were 3 important outcomes of that concurrence being viewed as the law. The first, Dean Smolla has already alluded to, it had a great effect in state lawmaking. The states all followed Justice Powell's lead, saying there's a qualified privilege, not an absolute privilege, but a qualified privilege for the press to shield its confidential sources. 32 states by statute and 17 states by constitutional interpretation or state evidentiary privilege making, common law interpretation, now have some form of qualified privilege. And that effectively mooted a lot of controversies when state prosecutors might have sought to go after their reporters. As the state prisons, the state jails were not full of the staffs of the local dailies because of that influence. But even in federal court, Justice Powell's concurrence had 2 important consequences. First, it became quite common for the courts to recognize a qualified privilege for reporters to shield their confidential sources in civil litigation, where there wasn't a defendant's Sixth Amendment rights at stake, where he really needed to know that information to confront the witnesses against him. And in civil litigation, it became common to say the reporter can shield his sources unless the government can overcome the high hurdle of showing that it really needs the information and it has no alternative source besides the reporter. 1981 decision by the DC Circuit started that trend, and many other circuits agreed. The Ninth Circuit found that privilege in a defamation case where said the plaintiff has not exhausted relevant alternatives. So first, there was a qualified privilege in civil litigation. And second, in the federal courts, there was even a recognition in many circuits of a qualified privilege in criminal cases when the government sought to get the reporter to turn over his sources. The Third Circuit in a case called Cuthbertson in 1980, in a fraud and conspiracy case involving some outtakes from 60 Minutes that the government wanted to get its hands on, said, no, we're going to quash the subpoena. The government hasn't shown it really needs those outtakes. Same thing in an 11th Circuit case in 1986 called Caporale, a case involving jury tampering, Or a case in the Western District of Pennsylvania in 1991, for example, quashed a grand jury subpoena which was seeking leaked FBI reports in connection with a corruption investigation. And the Western District of Pennsylvania judge said, I read Justice Powell in Branzburg to say that the government needs to show it has exhausted its alternatives. If these leaks were coming out of the government, we think the government has a good opportunity to exhaust other means of investigation besides subpoenaing the reporters. So just to summarize, Justice Powell's Branzburg concurrence rules the nation 3 ways from about 1972 into our current era, through influencing the states to adopt and increasingly adopt a qualified privilege as a matter of state law, in influencing federal circuit courts to create a qualified privilege in civil litigation, enabling reporters to keep their confidential sources unless a plaintiff shows it really, really needs that information and can't get it elsewhere, and even in criminal investigations, shielding reporters against grand jury subpoenas, telling the government it has to clear a high hurdle of assuring the court that it can't get the information elsewhere. Now let's turn to chapter 3 of the story, our current era. As Dean Smolla suggested, the tide has turned. Increasingly, we see that it's Justice White's plurality opinion saying no First Amendment privilege for reporters to shield their confidential sources that gets cited as the law of Branzburg. And Justice Powell's concurrence gets increasingly ignored in current cases. We see that, for example, reporters in civil proceedings have been held in contempt for failing to turn over their information. This in the Wen-Ho Lee case, the case of the Los Alamos scientist accused of having passed over intelligence secrets to foreign powers. He brought a Privacy Act challenge saying, I was wronged, I want information from the government to clear my name. And in the course of that Privacy Act challenge, he sought to subpoena, to obtain discovery, civil discovery, not of information from reporters who had covered the story. And the DC Circuit, in an important 2005 decision, said, I'm sorry, Branzburg, Justice Powell, that was a concurrence. The holding in Branzburg was no First Amendment privilege for reporters to shield their sources, and in this case, it upheld the contempt against these journalists for violating a civil discovery order, reading Branzburg quite narrowly. Also, in recent criminal cases, especially in the leak context, as Dean Smolla has already alluded to, the court has now, the lower courts have tended to read Branzburg quite narrowly and to say there's no privilege. There's almost an absolute rule, according to some of the lower courts, that if there's a grand jury subpoena, all bets are off. Reporter loses. Turn over those sources. There's no privilege whatsoever. There's almost a rule in favor of the government rather than a balance. The Judith Miller case in the DC Circuit in 2006, no special press privilege in a grand jury subpoena case. The McKevitt case out of the Seventh Circuit, in which influential Judge Richard Posner said, I've read these cases in which people seem to be relying on this opinion by Justice Powell. Did anybody notice that it was a concurrence in a decision holding that there's no privilege? And in this case, he held that a foreign criminal defendant could obtain information from a reporter about secret sources in a case that was relevant to the foreign criminal prosecution. This case was overdetermined because the confidential sources had waived the privilege, and to Posner, who thought that it's the source who owns the privilege, not the reporter, that was the end of the matter. But if you don't want to focus on McKevitt, take 2 more cases recently, a First Circuit decision in 2004 in Ray Special Proceedings, a case involving corruption by city officials and an ongoing investigation, criminal investigation. There, the First Circuit said the privilege is rejected so long as the information is not readily available to the government through a less sensitive source than the reporter. The presumption is shifted. Under Justice Powell's First Amendment, there was kind of a presumption in favor of the press, and the balance would tip only if the government showed it couldn't get the information by other means. Now the presumption was kind of in favor of the government. If it was too inconvenient to find another source, then we would exercise the contempt power of the court over the reporter to cough up the sources. Or New York Times against Gonzalez, Second Circuit in 2006, saying there's a limited privilege. Maybe there's a limited privilege in a grand jury subpoena case, but it's easily overcome by the government. All right. So those are just a few examples. Judith Miller, Wenho Lee, McKevitt, In re Special Proceedings, New York Times versus Gonzalez, in which suddenly it's Justice White's plurality opinion and not Justice Powell's concurrence that dominates the reasoning, and the privilege claims are rejected again and again. The presumption seems to be in favor of the government, especially in grand jury subpoena cases. Now, what I want to do next is say what changed between those two eras. Justice Powell's First Amendment that dominated for 3 decades, and the switch now toward a deference to governmental requests and plaintiffs' requests for information from reporters about their confidential sources. And I want to suggest to you that there are 3 changes in the backdrop, in the social, institutional context in which these cases arise. First is one that Dean Smolla already alluded to. First is a change in the nature of the press. Who is the press? It's no longer the Columbia School of Journalism graduate following the code of institutional self-restraint, 2 sources, corroboration, fact-checking, getting your info. It's people in their pajamas blogging in over coffee. So the press is no longer a confined institution with a hierarchy and a set of institutional codes and self-regulation that can be relied on, as I think Justice Powell's First Amendment did, to make selective use of confidential sources, the rise of the blogosphere. There's a change even within the institutional press in which there's been an increased reliance on confidential sources. After the success of Bernstein and Woodward in unmasking the Watergate scandal through the use of the confidential source in the parking garage, Deep Throat, whose identity we finally learned shortly before his recent death, now every reporter wanted to have a deep throat. Now every story was done with confidential sources. The kind of casual and excessive use of confidential sources made it somewhat pedestrian rather than the kind of thing the reporter only did when he had to infiltrate the secret meeting. And of course, there were some prominent cases where the confidential sources did turn out to have been fabricated, and then that was like the 13th chime of the clock. It made the public wonder whether other confidential sources had been fabricated too. And it may be that this kind of promiscuous use of confidential sources was encouraged by the rise of the state shield laws that encourage reporters to be bolder as against state prosecutors in knowing that they wouldn't get caught. So first is the change in the nature of the press. Second is the change in the nature of the government's approach to self-restraint. Now, I know you're going to hear later from our very distinguished prosecutors who are with us today, for whom I have the greatest respect, and I know you're going to hear from them about the Department of Justice guidelines and how important that those guidelines in place since the 70s and now codified in 28 CFR. Justice Department has a set of guidelines that says we will only go after reporters under exigent circumstances where there is need and where we have exhausted alternative sources. And in fact, they'll tell you that these requests for reporters' confidential sources are therefore very relatively rare. Chuck Rosenberg testified in 2005 before Congress that there had been only 12 press subpoenas in 15 years. And there's an arduous set of internal procedures you have to go through to get clearance. But in the last 2 years, by my count, there are 10 different news outlets that have been subpoenaed in the litigated cases I've just described. 4 subpoenas alone in a case I had a privilege to represent a newspaper in. Full disclosure, I helped to represent the Hearst newspapers and the reporters who broke the Balco steroids scandal, the story about the manufacturer near San Francisco that was allegedly supplying illegal steroid substances to many famous athletes. Most famous is Barry Bonds, but there were many others. There was a series of articles in the San Francisco Chronicle published about this grand jury proceeding investigating the underlying drug distribution. But the subpoenas arose in the Balco case after the indictments had come down, after the government had already produced Jenks material to the defendants. So there was discovery material that was going to the trial. And in fact, the case about the subpoena was litigated after the defendants in the underlying drug distribution scandal had pled and served their time. So this was not a case in which the government was subpoenaing information about leaks in order to investigate an ongoing crime or prevent an imminent crime. It was a case that was really retroactive. So, and there were 4 subpoenas in that case alone. Now, I give that as an illustration of what is perhaps a more promiscuous use of subpoenas on the government side, more promiscuous use of confidential sources on the press side, more promiscuous use of efforts to get at reporters' sources on the government side. even where there is diminished governmental necessity, the war on terror is one thing, but the war on steroids, different matter, perhaps a different degree of necessity, less exigent circumstances. And as I've suggested, this was a case in which this was retroactive, it was after the fact. And second, where you can question whether there was really exhaustion by the government. If you think about a leak case, the government has ample opportunity to do internal investigation to see if there's a government source who is the leaker without going after the reporters. And it also has the power to subpoena and seek testimony under oath of all the people within the coercive power of the grand jury process, including the defense lawyers, to see whether under oath they deny being the source. It turned out in the Balco case, and that's what mooted the appeal to the Ninth Circuit, that the defense lawyer had been the source of the leaked grand jury transcripts. He later was outed by a Confederate and is now pled and is getting a sentence higher than what was recommended. But this was a case when she was never called in under oath. So the government had gone after the reporters before, I would argue, exhausting every alternative of internal investigation or subpoenas under oath of the possible sources in court. Third change, promiscuous use of sources by the press, more promiscuous use of subpoenas by the government. A third change is really in the interaction between the two. The dangerous liaison between the press and the reporters, a rise of leak culture in which there's a cozy relationship, the relationship that was on display during the Scooter Libby trial, as reporter after reporter came to the stand and described daily life in Washington as being a series of conferences, breakfasts, lunch, and calls, in which the danger is, as I think Justice Powell anticipated in Branzburg, the press might become the pawn of government, that the press might become manipulated by government or subject to the selective distribution of information by government under the guise of a confidential source. That kind of dangerous liaison is a change too. I'll close by saying that those three changes may make things look different today, but as much changes, much is still the same. That the context may have changed, but the first principle is no different. That the solicitude for the First Amendment should still guide our thinking. And I think if we asked what would Lewis Powell do, WWLPD, if we channeled him into this room right now, I believe that the need for a Powell-like balancing is more, not less important, given those three changes I've described: the change in the culture of the press, the change in the culture of the government, the change in the culture of the relationship between them, for several reasons. First, in a war on terror, in times of national security crisis, it is more important, not less important, for an enlightened citizenry to be able to know what's going on about the execution of that war by its government. I'll quote from Zechariah Chafee, a famous First Amendment defender on the Harvard Law faculty at the beginning of the century. He wrote an article in 1919, just as the government was passing amendments to the Espionage Act to try to contain anti-war efforts during World War I and the United States' entry into the war. He said it is precisely in times of war that we need more, not less, secrecy from governments so that the citizenry may decide whether the terrible costs of war are justified. So I would echo Dean Smola's closing remarks in saying that the vital need for an informed citizenry and the protection of leaks to the extent they are protection of reporters' confidential source information to the extent that's necessary to getting information to an enlightened citizenry is more important to democracy than ever. Second, to the extent we're talking now about leaks, rather than, remember, Branzburg arose in a prosecution of drugs, arson, firebombing. The case was about underlying crimes. And in a way, going after the speech, going after the reporter's news gathering was just ancillary to that clearly content-neutral effort at law enforcement. But a leak investigation goes after speech and nothing but speech. And we always worry more when the government is going after speech and nothing but speech, rather than just going after speech as a tool at getting at another end. It's a far cry from investigating or preventing crime independent of expression. So I think if we were to say, what would Lewis Powell do? I think that he might do something like what judges like Judge Tatel on the D.C. Circuit or Judge Sack in dissent in the Gonzales case in the Second Circuit suggested we ought to do. They said, in a leak investigation case, before you go after the reporter, we ought to ask, not only does the government really need it, and has it exhausted all alternatives? Has it done a sufficient internal investigation? Has it asked the court to ask everybody, including the defense lawyers under oath, whether they're behind the leaks? In a leak investigation, say Judges Tatel and Sack, in Tatel's concurrence in Judith Miller and Sack's dissent in Gonzalez, they said, we ought to also balance in court the harm that the leak causes. That can be a terrible harm when you're outing the covert identity of a CIA agent against the value of that information. That information, the identity, may have no public use, and Judge Tatel, in applying the balance, said it was an easy case for him to say that the Judith Miller subpoena ought to be enforced, that the harm of the leak of Valerie Plame's identity outweighed any good to the public from that revelation. Or Judge Sack suggested a similar balance in Gonzalez, and I tentatively suggest, subject to correction by Justice Powell's son and daughter, that he might have thought that that kind of balance was appropriate in a leak investigation. Now, I think Justice Powell also would have said, now let's be cautious. There are dangers in that kind of balancing, the good of a leak against its harm. One is, who's the press? Defining who the press is and even deciding who gets to invoke the privilege creates a danger of making government a licensor. It's been a big headache in the draft bills to pass a federal shield law to figure out how to define the press and how much of the blogosphere to include. Second, you might worry that balancing may sound good, but in the end always favor the government. A learned hand many years ago in the Masses case during World War I and the Red Scare afterwards, he said, we should have bright line rules under the First Amendment. We shouldn't have balancing because it lets, he wrote in a letter, it lets Tom, Dick, and Harry DJ, Tom, Dick, and Harry district judge, decide according to his own predilections. And so he says, I don't like Holmesy's tests. Wouldn't you like to be able to call Justice Oliver Wendell Holmes Holmesy? That's why I don't like calling it. So you might say balancing may tend to just favor the government anyway. And finally, I think Justice Powell might have said, be cautious in balancing because to allow judges to weigh newsworthiness is to create the danger that their subjective preferences about what is and isn't newsworthy will intrude. I can tell you that there were Pulitzer Prizes for many of the stories that are behind the leak investigations underlying the Miller case, and there were many awards to the reporters who broke the Balco steroid story, and many who would say that that was a noble service because it got steroids out of not just professional sports, but out of college and high school sports where steroids could really cause lasting harm. But I think he might caution those that having judges weigh newsworthiness should be done with caution. But I think in the end, Justice Powell would still say, I think I was right the first time in Branzburg versus Hayes, that the only way to deal with these changes in the background circumstances, the rise of the new access to information provided by the internet, the government's felt necessity in a war on terror to press the press harder, and these new dangerous liaisons between press and government, the only way to address that is with solicitude for the First Amendment and with balancing. And I think he would say that even if it's right, that even if it's true that the government will win lots of these cases once they're litigated, it's very important to balance anyway because it forces the government to have to articulate its reasons for asking reporters for their information. And I think he might recall the phrase often invoked by his colleague Justice Thurgood Marshall on the court. Marshall used to say the value of the sword of Damocles was not that it falls, but that it hangs. That if you have to come to court and justify yourself under the First Amendment, you won't tend to be too rushed to violate it in the first place. So I venture to close by saying, what would Lewis Powell do? He would say, I was right the first time in Branzburg versus Hayes. We need judicial balancing to have solicitude for the First Amendment, even while we protect the important values the nation seeks to honor in the war on terror. Thank you very much.
Thank you. I will be very brief. I have dealt with the press in 4 different government jobs. First time was as an assistant U.S. attorney in New York when Rudy Giuliani was the U.S. attorney. And I had been told that the most dangerous place in New York was actually not crossing Fifth Avenue by Rockefeller Center between the crosswalks, but it was between my boss, Mr. Giuliani, and a microphone. I was a brand new assistant U.S. attorney. And I was at a press conference with Mr. Giuliani, and I was standing behind him. And after he gave his prepared remarks, he stepped back slightly, and a reporter asked a question. And it was clearly a question he didn't know the answer to and that I did, this 26-year-old assistant U.S. attorney. And I froze because I'd remembered what I'd been told by my seniors about crossing that space. And there's a picture, actually, that I have of me standing there frozen and Mr. Giuliani slightly off center. And it wasn't until he turned and nodded to me that I stepped to the microphone, risking my life, and answered the question. I had almost no dealings with the press as an assistant U.S. attorney in New York. Then I got to Richmond as the managing assistant U.S. attorney, and I dealt with the press as we would announce our indictments and arrests and searches and seizures and results in significant cases. And it was then that I came to realize more acutely than I had in New York just how vital the press was to what we did for a living as federal prosecutors. We sold a product, which was general deterrence. And the only way for us to sell it, to deter would-be bad guys, was to get the press to tell the world about what we did. So I learned a lot about the value of the press. I also learned something about the responsibility of the press. There were a number of times in Richmond when reporters got wind of arrests that were imminent or searches that were imminent and came to me and asked me about it and told me about it in advance and agreed to hold stories when I explained what would happen, the dangers that would face a law enforcement officer going through a door if somebody knew they were coming. They were very, very responsible about protecting information when lives hung in the balance. Now, of course, they always wanted something in trade, and I don't mean pens and pads. They wanted a heads up on something that maybe was more appropriate for them to know. And we struck balances. We made those trades to accommodate their compelling need to publish and to tell the world, a need, frankly, that we often supported to try and get our word out, and our need and their need, because they are people who care about other people, to protect what matters most. Then I got to New York in the job Mr. Giuliani held. I was the United States Attorney in Manhattan, and among other things, indicted Martha Stewart, and learned that you needed 2 risers for the cameras when you indicted a major national security case, but you needed 3 when you indicted Martha Stewart. And there was much more interest in that important matter than in some of the other things we did. And I learned an awful lot about the role the press plays in getting the message out, the message of deterrence we tried to send in the summer of 2002, what I call the summer of corporate fraud. I also learned how important it was for the prosecutor's office to interact with the press, to give them information they want, public record information most often, but sometimes an off-the-record chat so they didn't go astray in reporting something about a pending case. Then I got to Washington, D.C., and I learned a whole lot of stuff that I never imagined when I was an assistant U.S. attorney with Rudy in New York, when I was the managing assistant in Richmond, or when I was the U.S. attorney in Manhattan. I learned, as Kathleen said, that there is, in fact, a symbiotic relationship between the elites, and I used to be an elite, thank God I am no longer an elite, the elites in government in Washington and the elites in the media in Washington. I learned that everybody leaks when they are not decrying leaks. And that, of course, raises the question of what is a leak? Everybody uses anonymous quotes. I should stop for a second. Not everybody. 2 branches of government leak like sieves, the executive branch and the legislative branch. The judiciary, I'm here to tell you, does not leak, and I'll get back to that at the end. I learned that leaks, so-called, can be a good thing. It can be important to be able to speak as a senior administration official about some initiative that's coming, to float it out there in a way that you'll be able to gauge response. It can be important on the Hill to be able to do that. It can be very important to do what people would call leak. I also learned that the press is in every room at the highest levels of government in Washington. And what I mean by that is both literally and figuratively. Figuratively first. There is a saying in Washington, inside the government, that everything leaks eventually. One of my colleagues, a very senior official, once said to me, the only way 2 people can keep a secret in Washington is if one of them is dead. Okay? Now, why do I tell you that? That has a remarkable effect on decision-making at senior levels in Washington, because Seated in that room with the decision makers is a figurative press, the press that will be the recipient of what the decision makers believe is the ultimate leak of what's being discussed there. And that focuses the mind in very, very important ways. We used to talk inside meetings about the New York Times test or the Washington Post test. How will we feel when this is on the front page of the Washington Post or the New York Times? It often changed decisions or drove them in a slightly different direction because of the figurative presence of that fourth branch of government. Remarkably powerful. I also said they were there literally. When you go to see the president in the Oval Office, as I did many mornings to do the terrorism briefing with the director of the FBI, you stand in an anteroom. And in that anteroom is kind of a coffee table, maybe a little higher than a coffee table. And seated on that table every morning are major newspapers from around the country, and then a thick printout of the clips, summaries of news stories that touch all parts of the federal government, organized by branch of the government. At the Department of Justice, every morning I would get emailed a version of that that focused on the Department of Justice's issues, and then there'd be a hard copy on my desk every morning. It is one of the very first things that the seniors, the elites in the federal government read every morning. I would get a terrorist threat briefing, and I would look at the clips to see what the media was saying about the work we were doing and what had ended up in the media that maybe we didn't want there. Extremely powerful figurative presence and literal presence. Official Washington has an obsession with what goes on in the media for a whole lot of good reasons, ones that I think you can imagine. They care the way the world is understanding what the government is doing. The prosecutors care about the messages of deterrence getting out. People care about what's said about them personally. But the headline is, the headlines matter tremendously and shape everything that goes on inside of Washington. And I'll get back to explaining why that matters so much in about 30 seconds. Some secrets must be kept. The first thing that surprised me is that not everything leaks. Okay? That remarkable story about what happened that night in the hospital, that didn't leak. Because I didn't leak it, and Chuck didn't leak it, and the people who were with me that night did not talk to the press about that. It was 3 years later that story got out when I was under oath and asked about it. Okay? Not everything leaks. But some things do leak and hurt important efforts, like law enforcement efforts and national security, counterterrorism efforts in particular. All of us would agree that some secrets must be kept, have to be kept. You can imagine your own. Troop movements, search warrants about to be executed, the undercover identity of a covert operative with the CIA. Some things can't leak. The flip side of that is, when they do leak, the government has to do something about it. Has to, because we care about the rule of law. We care about some secrets not being disclosed. And you can imagine the kind of world we live in if we never pursued a leak when it mattered most. So we have to investigate the leaking of some secrets. So how do we do that? I agree with my colleagues that a balancing test is the most appropriate. But I believe that balancing is actually best done the way it's been done, as you heard, for the last 34 years under the Department of Justice's guidelines. I believe that journalists should be careful about what they ask for when they talk about wanting statutory balancing enshrined in law so that federal judges do balancing around the country. I frankly think journalists would be worse off. Remember I said I'd get back to the influence of the media? I have sat there and reviewed requests from federal prosecutors to subpoena media organizations for their phone records or for their bodies to come in the grand jury so they can be asked about confidential sources. In every one of those meetings, it's required by the regulations, is the head of public affairs for the Justice Department. He is there as the voice of the media, or she, and what he or she is saying at every one of those meetings is, if we do this, we're going to get killed. The press is going to be furious. They're going to nail us in every story for the next 10 years if we do this. And we care about that. They're in that room. The press has power. I hate to be on camera telling them this, but the press has power that maybe they don't even imagine from the outside, inside the government. Now, why does that matter? Because when I'm doing the balancing, with the voice of public affairs there and the voice of a whole lot of different institutional interests that have been there for years and years, I'm being very, very conservative, as I think have all of my predecessors as Deputy Attorney General and all Attorneys General. I turned down a whole bunch of requests for most of the reasons that I laid out. Our fear of the reaction it would create in the press, our fear of being too aggressive, our fear of our inability to foresee the unforeseeable. I think if you shift that process outside the Department of Justice to the one branch that doesn't leak, remember I told you that? The judicial branch does not care how the media views them in the way that the executive branch does, or the legislative branch does. I guarantee you've never walked into a judge's chambers and seen news television on all the time, or clips on the table. They are not worrying about it the way we were worrying about it. I think you'd also see the Department of Justice feeling a little freer to ask for permission because they wouldn't take the hit if the reporter was subpoenaed. Who would take the hit? The judge would take the hit. I think reporters ought to be careful how hard they press for a change from that which has worked so well for the last 34 years. I think a balance is appropriate, and I think especially in these national security cases and law enforcement cases, it is best struck inside the United States Department of Justice. Thanks for your time.
This is for Dean Sullivan. Given the nature of leak cases where oftentimes it's just one source in the government telling the reporter whatever the information is, in cases where the government's interest would win on balance, how liberally should we construe the exhaustion requirement that you're talking about and that Judge Tatel talked about?
I think the government should still have to show to the judge that it really exhausted. I think exhaustion is a real issue, and relevance is a real issue. Cumulativeness in some of these investigations, how many reporters do you have to subpoena before you go after things? So I actually think having to demonstrate those things before a judge in camera if necessary. I mean, let's not forget that lots of the lower court cases have said the judge can review the government's showing of exhaustion and relevance privately rather than publicly. I think that having to go before the judge, and even I think Mr. Comey's described beautifully what the effect of a balancing test is. It forces self-regulation because you want to come up with the evidence that you could justify the request if you're forced to before the judge, even if you never have to get there. So I think if it ever does get to the judge, it ought to be a stringent requirement.
Also for Dean Sullivan, if you assess a privilege on a case-by-case basis, doesn't that mean that the sources are essentially gambling on the newsworthiness or the importance of the information they're leaking? It just seems to me that if it's going to be assessed later, being subpoenaed after the fact and losing is not going to be very reassuring to me as a source.
Yes, the question is, are its sources gambling if the privilege is assessed on a case-by-case basis? And I think the answer is yes, they are. And sometimes the press betrays them. There's a wonderful case called Cohen versus Cowles Media, in which the press revealed the identity of its source. A staffer in candidate A's campaign leaks that candidate B had been arrested for a shoplifting offense years ago. The press says, well, it's relevant to disclose that the source is candidate A's staffer. Candidate A's staffer didn't last on that staff after this was revealed, and he sued for violation of contract. You breached your contract to me. So sources are always gambling, and Justice White, the author of the Branzburg plurality opinion, said, tough luck, newspaper. If you breached your contract, you ought to pay. You can't, on the one hand, come in and say, oh, we need to keep the confidentiality of our sources, but we don't have to pay when we breach it. So first point is the sources are always gambling on the press to begin with. But second, I think it's not a bad idea to have sources a little uncertain about how guaranteed the confidentiality is, because that helps to push us back into self-restraint on the press's side, so that the press isn't overusing sources when it ought to use old-fashioned shoe leather instead of the anonymous source.
For Mr. Comey, do you feel like the global war on terror changed the balancing act in the Department of Justice, both in terms of national security cases going more aggressively after the press, but also not accommodating freedom of information requests and more secrecy versus open government?
The question was, do I think that the global war on terrorism changed some of the habits and balancing inside the Department of Justice? I don't think so with respect to the press. I mean, I'm sure Chuck Rosenberg will answer. It sounds like it all went to heck after I left. But I don't think so. I mean, you've seen some high-profile stories that have implicated some of these issues, driven by the fact that there were a variety of counterterrorism programs that became controversial and were disclosed to the media. The secrecy question is probably beyond my ken, although I have the same reaction a lot of journalists do. I would see stuff inside the government that was stamped secret, and for the life of me, I couldn't figure out why it was. I think that's just, frankly, I don't think that's part of an evil plot. I think that's just the easiest thing to do for a whole lot of people. It takes a lot more time to figure out what is and isn't secret. You just stamp everything with this thing you got on your desk. You can move on to the next item, and that is not a good thing. I mean, but that's a whole nother symposium.
Just a quick addendum. Jim, I was struck by your claim that the judiciary doesn't leak, and it's true, I suppose, for the most part. But there is a kind of transgenerational leak process in that justices, some of them at least, later leave us their papers. And remarkable journalists like Linda Greenhouse write books about Justice Blackmun, or Joan Biskupic about Justice O'Connor, and I feel almost as if I'm in the possession of a leak. Because this is from the secret chamber. This is the scorecard in Branzburg versus Hayes in Justice Powell's handwriting. And you see the deep ambivalence because, as Kathleen has said, there was this solicitude for the First Amendment, a nice euphemistic word, solicitude, right, that he uses. But it's fascinating to actually look at the handwriting. He's got Douglas, reverse, Marshall, reverse. Reverse is for the press, all right? Brennan, reverse. Stewart, reverse. Uh-oh, here come the late returns from downstate Florida. White, affirm. Blackmun, affirm. Rehnquist, affirm. Chief, affirm. It's 4-4. And here's Justice Powell in his own handwriting. Affirm, as I do not think there is a constitutional privilege. How interesting. That's why I think there may have been a balance, and he may have wanted us to get it back the way he originally intended, but I'm not sure even he, at this moment, was quite sure what he intended.
Well, just to follow up on that, there's only one express constitutional privilege, and that's the Fifth Amendment privilege against compelled self-incrimination in a criminal case. And so, in a sense, he might say there's no First Amendment privilege that you can derive simply from the text, but I don't think there's any question that he was trying to infuse First Amendment thinking into the balancing process that would otherwise come up in a grand jury subpoena evaluation under Criminal Rule of Procedure 17 or so forth. So you're right. Solicitude is not the same thing as a right, but I don't think it's chopped liver either.
I agree, and actually, if you think about the connections between both of you on this, it's this interesting tension between the informal arrangements and self-restraint and institutional traditions and respect for the values of the First Amendment and making it a formal rule of law, which maybe some of us would prefer, but he was clearly on that edge between those two.
So I guess I think that his sense of solicitude would increase and veer closer to a privilege or a right the more he thinks that self-restraint is breaking down. And then just to follow up on the last question, I do think there's been a rise in the culture of government secrecy, sometimes in places where we later wonder, why did that have to be secret? And it's come up in lots of matters, from the Energy Advisory Committee run by the Vice President to the discussion of the warrantless surveillance program by the National Security Agency. And when these things, if the government's going to increase the culture of secrecy, then leaks become as disreputable and undesirable as they might be as a general practice, sometimes the only window into government practices. So I think to the extent that solicitude is a kind of sliding scale, it would be responsive to the secrecy and breakdown of self-restraint on the other side. So I'm just speculating that he wouldn't necessarily say it was a First Amendment privilege, but his solicitude might have increased.
Well, 10:30:00, so we break now for 15 minutes, come back at 10:45 for the second panel. Thank you very much.
welcome to the second session of the Powell Symposium. For this panel, we have very distinguished guests. The first person is Chuck Rosenberg, who is a United States Attorney for the Eastern District of Virginia, a position he has held since March 2006. As the Chief Federal Law Enforcement Officer for the districts, which includes Alexandria, Newport News, Norfolk, and Richmond, Mr. Rosenberg supervises the prosecution of all federal crimes and the litigation of all civil matters in which the federal government has an interest. He has also served in several senior posts at the Department of Justice, where his work is focused on counterterrorism, counterintelligence, and national security matters, including being the Chief of Staff to Deputy Attorney General James Comey, Counselor to Attorney John Ashcroft, and prior to that, Counsel to FBI Director Robert Mueller III. Before joining the FBI, Mr. Rosenberg was an Assistant United States Attorney in the Eastern District of Virginia in Norfolk and subsequently in Alexandria. He prosecuted financial fraud crimes, violent crimes, and espionage cases. During the last 2 years of his tenure as a federal prosecutor in Alexandria, Mr. Rosenberg supervised that office's major crime unit, the unit that prosecuted numerous prominent spy cases. Mr. Rosenberg, who also spent several years in private practice with the law firm of Hunton & Williams, holds a BA from Tufts University, as well as Masters in Public Policy from Harvard and a JD from the University of Virginia. With us today, we also have David Weston, who is the president of ABC News, a position he has held for 10 years and in which he is responsible for all ABC News work, including World News Tonight, Nightline, Good Morning America, 2020, and ABC News Radio, abcnews.com, and ABC News Satellite Service, News One. Under Weston's leadership, ABC News broadcasts have been honored with more Emmy nominations than any other news organization, as well as 4 Edward Murrow Awards and Columbia University's Alfred I. DuPont Award. Prior to joining ABC in 1991, Mr. Weston, a summa cum laude graduate of University of Michigan Law School, was a partner at Wilmer, Cutler, and Pickering. He also taught at Georgetown and Harvard Law Schools and is the co-author of a treatise on international civil litigation. Prior to that, and most relevant to our endeavor today, in 1978, he served as a law clerk to Justice Lewis Powell. Mr. Weston serves on the board of the Associated Press as its sole outside director from a broadcast news division, the board of the Newseum, the board of the National Constitution Center, and the board of the Youngcast Partners in Education. He received a BA degree with honors and distinctions from the University of Michigan in Ann Arbor and a JD degree, summa cum laude, from the Law School of the University of Michigan. Mike Allen is the chief political correspondent for Politico.com, an online news and comment blog. Before he moved online, Mike Allen was well known as the White House correspondent. Prior to that, Allen spent 6 years at the Washington Post, where he covered President Bush's first term, Capitol Hill, campaign finance, and the Bush, Gore, and Bradley campaigns of 2000. Before turning to national politics, he covered schools and local governments in rural counties outside of Fredericksburg, Virginia, for the Freelancer, and then wrote about Oliver North, Chuck Robb, and the Bobbies for the Richmond Times-Dispatch. Allen also covered Mayor Giuliani, the Connecticut State House, and the Wacky Ridge of Greenwich for the New York Times. Before moving to the Times, he did stints in the Richmond and Alexandria bureaus of the Washington Post. Allen grew up in Orange County, California. He has a BA from Washington and Lee University, where he majored in politics and journalism. The format for this session is going to be slightly different from the previous one, and the panelists have asked that this be done in an interactive format. I guess when you have two journalists on the panel, it tends to be a little different. But I'll ask them to come up here and make a few remarks, and then they'll go back to the stage, and we'll have an interactive format. Thank you very much.
Good morning. There's a bad draw in public speaking. It's following Jim Comey. None of us wanted to do it. I got the short straw. Jim is smarter, taller, funnier, more intelligent than me. So I'm not going to draw out that comparison for very long. Mike and David and I all agreed that we would do something a little bit different, which was to talk among ourselves more in a dialogue, and to invite a lot of questions from you, because you're here because you're interested in this topic. I have probably 3 or 4 minutes worth of remarks, but really what I want to do is try and raise some topics for discussion, feeding off of some of what was said in the first panel. An example, Dean Smolla had mentioned that 49 states have some form of a privilege, a shield law, some by statute, some through case law. The point I would make, in fact, the point I will make, is that the federal government is materially different. Ohio doesn't classify information. California doesn't classify information. There's no such thing, as far as I know, as top secret Virginia information. The federal government does, however. We have a different responsibility, obviously a different classification structure, and so we protect information as a federal government that would not be protected by the states. Now, I think Jim Comey is quite right. I agree, much of it is overclassified, but that's not the issue today. The issue is whether you can really make a valid comparison between the responsibilities of the states on one hand, almost all of which have some type of shield law, and the federal government on the other. Another topic perhaps for discussion, Professor Sullivan spoke very eloquently and mentioned the notion of institutional restraint and suggested that Justice Powell would expect that. Jim Comey mentioned that we have what I think is tremendous institutional restraint. My numbers are a little bit old, and Professor Sullivan's are probably a little bit better. But on average, we seek maybe 1 or 2 confidential source subpoenas a year. Now, we seek many other types of information from the media, toll records, for instance, or outtakes, where something has been broadcast and we want the rest of the tape. But that's not confidential source information, and that's what is really at the heart of this debate. And so understand that when we talk about confidential source subpoenas, we're talking about a very, very small number, and that we have a vigorous internal process to screen requests from prosecutors around the field for that kind of information. I was an AUSA for about a decade, an assistant U.S. attorney. I never asked for a media subpoena because it takes too darn long, and I knew I wasn't going to get it because our internal standards are pretty darn high. And so I think we do have sufficient institutional restraint. My friends perhaps might disagree, but that's something I think we ought to talk about. And finally, let me just throw out one other possible topic. Who holds the privilege? A little more esoteric than guys like us tend to get into, although David is a Supreme Court clerk and would certainly address it well. But in all the other contexts that you heard about today, in the attorney-client privilege context, it's the client who holds the privilege, right? In the priest-penitent context, it's the penitent who holds the privilege. Here, somehow, it's gotten muddied. We think about it as the journalist's privilege. Really, the journalist is the recipient of the information. If there's going to be a privilege, shouldn't it belong to the source? I said that was my final report, my final point. I misled you. I have one other. But this is really it. There is a certain irony afoot when with Congress, when it seeks to legislate a privilege for journalists or their sources, as the case may be. Because remember, it's the Congress that made the disclosure of certain information in and of itself a crime. If you leak grand jury information, it's a crime. If you disclose classified information, it's a crime. Now, sometimes, maybe often, the only person who has evidence of that crime is the person who leaked it and the person who received it. Now again, we're different from Ohio or Virginia or California. If we are to investigate that leak, and we're not the ones who made it a crime, where do we go for that information? Okay? To the people who have the evidence. Just like in a bank robbery, you talk to the tellers. This is not really all that different. I promised you that was my last point. It is. Let me ask Mike if he wants to say a few words. But again, we're going to try and make this much more interactive.
Thank you very much. Well, good afternoon. And being here gives new meaning to reporter's privilege. I've had such a delightful time here. It's a privilege to be here for several reasons. First of all, I have the honor of addressing my first boss, Mr. Charles Rowe, who's in the front row here. He's a great friend of Washington Lee, a great friend of the First Amendment. He was the owner of the Fredericksburg Freelance Star when no one else would give me a job. And so it's all Mr. Rowe's fault. And before I had a more rigorous ethical framework for making my decisions, when I was a brand new reporter, I used to think to myself before I did something, how would this make Mr. Rowe look? Or how would Mr. Rowe feel about that? So that was my first test. And it's still not a bad one. Second, such a delight to enjoy Washington Lee students. Yesterday I got to enjoy your hospitality, checked out the mock convention, which is coming up, and replugged in to campus life, and that is always a great privilege for us. And what an honor to be talking to the Powell family, who has all been great friends of Washington Lee, but also remind us of a great Virginian and a great American. When I was a brand new reporter at the Richmond Times-Dispatch, Justice Powell was generous enough to have me over to his chambers for an interview. And at the time, I certainly didn't realize that there was nothing in it for Justice Powell to have the rookie reporter from the Times-Dispatch over. I'm sure I didn't ask him sufficiently acute questions. I did look into his biography, talk to him a little bit about his life in Richmond, discovered one of the lesser-known facts about his biography, that some people would say that he had taught night school, but when it's Justice Powell, it was evening university. And so we got to talk about that. But it was a reminder to me of how someone who's achieved great things can help get someone else on the road. And so talking here about Lewis Powell's First Amendment, as Dean Sullivan put it, was a great expression. Now, I'm here today as the literal blue collar on these panels. I'm the person who's out there trying to convince people like the gentleman here to engage in the dangerous liaisons that Dean Sullivan mentioned. A small example of the sort of things, try and convince people to hold our hands, to trust us personally, that we'll protect their identity, and to trust that we will use the information in the service of either explaining what they're going to do or, in some reason, contributing to the public dialogue. And sometimes it's just what they have to say is just interesting, and we do that too. The last couple of days I've been, at this very moment, probably in the last half hour, the president was in the Rose Garden announcing his new attorney general, who's Judge Mukasey of New York, who many of the people here know. And so I spent the weekend teasing out of the administration should I be closer or further? Teasing out of the administration and other people who knew what was going on, the fact that he was going to be appointed until the last couple days. People thought that he had been on the list of finalists as a sop to Democrats. Nobody thought that he would really be appointed. And so we're trying to figure out what's happening, but also to try to explain to our readers, viewers, clickers, why that decision came about. And that's the sort of area where confidential sources can be very valuable, because the people who know, the true decision makers, will never say anything on camera about why that decision was made, besides that he is a great American, a great lawyer, the best man for the job. If they're talking to me as a Republican familiar with the administration's thinking, they will explain that he's someone that could be confirmed and could get to work right away at a department that is demoralized, distracted, desperately needs a leader, doesn't need to have their new boss go through several months, perhaps, of confirmation hearings with no certainty about how that's going to come out. And so what we do is a little messy. The earlier speakers, what they do is very organized. They more are Gertz, the finished product. It's stable, it's settled law. We're Branzburg. We're an incomplete thought. We're the tiles in the mosaic. And so I ask you to think about that as some of these cases come up. It's the scrutiny that goes into casual and swiftly made decisions, which Dean Sullivan has experienced with some of her clients, is very humbling and heart-arresting. I can never forget seeing a wall-sized blow-up of the email that one of my colleagues at Time Magazine, Matt Cooper, had sent in the CIA leak case. And what arrested me about it was how normal it looked. Like it was in our same font, it was how our emails looked. And it was to his boss, and it's the sort of thing you would say to your boss. And it had provoked like unbelievable agony on many, many sides. And so one thing that we discover when we are the blue collar is that something that you can do quickly, that you do as a matter of course, can have tremendous consequences. Some of my emails were entered as exhibits in that case, and as they attempted to discover some of my sources. And one of the things the FBI agents did was they would take emails that I sent to two different people about the same topic and try to read into the assumed knowledge, the inflections, the differences in the email, my level of familiarity with that person, and to what degree that person might or might not have been helping me. And they would show the two emails to some poor person who worked at the White House and might or might not know me, and they'd say, okay, in this email he said this, in the email to you he said this, why is that? And again, a reminder of how cautious we have to be in cases like this and how technology is changing what we do. It's helpful. Many of the sources that I have would never take a call from me, and more to the point, I wouldn't call them because they would either be falsely accused of helping me or even worse, accurately accused of helping me. So email facilitates much greater information out of the government, but it also, just like the divorce cases that we read about yesterday in the New York Times, also can make it more easy to discover what we're up to or attempting to be up to. I'm going to close with a quote from Al Newharth, who founded USA Today, which I think is celebrating its 25th anniversary right now. And of course, he was the former chair and CEO of Gannett. He was on C-SPAN this weekend, and a very fascinating Q&A, but he made the point on there. He said, the Constitution guarantees us a free press, but we in the media are the ones who have to guarantee a fair press. And he made the point that the First Amendment might not pass today. If it had to pass Congress, had to be sent to the states for ratification, it might not pass. And I think my fellow panelists will agree with me that that's partly the fault of the media. As he put it, the fault of the photo editor who digs through and gets the ugliest photo of someone. One time we had somebody who we were writing about in the paper every day, and he would never talk to us. But one day he just mysteriously dropped off a new photo and said, please use this photo. And he still didn't talk to us, but he wanted a slightly more flattering photo in the paper. And so we have an image problem that results from that people are suspicious of us, that in a blogging culture, if you're at the MSM, people are nitpicking, sometimes very correctly, sometimes not, at us. My father one time, who was a conservative Republican, didn't have much time for what's now called the mainstream press. One time there was a photo of a columnist in the paper. He had a big shaggy hair, And my dad said that they should run the photos of all the reporters because then you wouldn't believe anything that you read in the paper. But so we have that image problem that's partly of our making, but we also have a substance problem that before, if we had something that was wrong, you might get a letter to the editor, you might get a call that you could ignore. Now, if we have something that is either arguably wrong or actually is wrong in the media culture of today, right away, you're going to know a lot about that, and everyone is going to know about that, and it's healthy in that it's a check on you. I'm happy to have someone who's an expert in a field dissecting what I write about something, but it also is cautionary. And the last point that I'll make is referring to the phrase that came earlier about institutional self-restraint. And as I thought about that, I realized that institutional restraint can only be made up of personal self-restraint. So one of the reasons that an exercise like this is extremely valuable to someone who's out trying to do the job each day is it gives us the opportunity to think about some of these issues, both why we enjoy the privileges we do because of the work of Justice Powell and others, and also the fact that it's now our responsibility to make sure that we've earned that. So thank you very much for listening to us, and we're looking forward to having a conversation with you.
As said, I'm David West, and I'm delighted to be here. Thank you very much to Washington Lee for inviting me, and particularly thank you to Josephine and to Louis for bringing us all together. It's a wonderful occasion. I wore a white shirt today. I thought about wearing a blue shirt. I don't know what would have happened if I'd worn a blue shirt. Before I make a very few points the way Chuck did, just to start the conversation going, I want to say something about Justice Powell. It's been said several times this is the 100th anniversary of his birth. Actually, as I recall, 2 days from now will be the 100th anniversary of his birth. It was September 19. So that was a major landmark date for the country, I think, as well as for Virginia and for all of us who knew him. But what is lesser known and frankly not cared about by a lot of people except for me is it is also, will be in 2 days, the 30th anniversary of Justice Powell's calling me up and asking me to be his law clerk. He called me up on his birthday, September 19 of 1977, and as a result, every year I call Louis up just to remember his dad very fondly. He was a wonderful man. Whatever good you've heard about him is not enough. He was an extraordinary human being, and I can tell you in all honesty, would have been, no matter what the job is he held. If he'd been a county commissioner, he would have been just as extraordinary, and we're just fortunate as a country that he got to serve in the Supreme Court. Now, I was not there for Branzburg. I clerked 78 terms, so I was 6 years after. He and I did work together on one First Amendment case. It was Gannett against DePasquale, which was a fight about access for press, access to pretrial proceedings, where Justice Powell wrote a concurrence. So I did have occasion to talk with Justice Powell several times about his views about the First Amendment and the press and clashes between the press and law enforcement. Unfortunately, I was 25 years old. I didn't take careful notes. I wish I had. I'd have a lot more to say today if I did. But I will tell you, and I hope Justice Powell wouldn't mind my recounting this, the one thing I really remember he said when we were just together in his chambers talking about one of the drafts is he said he had a great deal of respect for the press in this country and its critical role in our government, and thought it was very important that we protect that role and respect it. And he didn't feel that he could ever be a journalist, because frankly he thought that a lot of the things we as journalists have to do he wouldn't want to be involved in. He respected the fact that we did it, but it's not something he personally would have done. So Justice Powell had nuanced views, perhaps even ambivalent views about the press, respected us enormously, but had some real reservations about some of the excesses that he had seen. That said, let me tell you from my perspective, because I run ABC News, as Professor Abba said, and to think about it for a second, news divisions in networks are a little different from newspapers. Newspapers have the distinction between the publisher and the editor. That is a pretty clear distinction between the business side and running the business on the one hand and the editorial on the other. Presidents of news divisions have to try to do both of those things. I'm responsible for the business side as well as the editorial side of what happens at ABC News, and often, obviously, they come together, and including when it comes to things like revealing confidential sources. Because one of the things we have to think about is what are the consequences for the corporation down the road if we're held in contempt, if we're sanctioned, if we have to pay fines. And it does affect what we do. Let me now make about 4 or 5 points, just as there are practical points. I practiced law for many years. I have not done it for even many more years, so I'm not going to try to vie with the exceptional law professors that we've had as well as the prosecutors. But let me tell you as a practical matter how this comes about. First of all, somewhat to your surprise, perhaps, this is not an everyday occurrence at ABC News. I do not go in every day and deal with confidential source issues. It is by far the exception rather than the rule. The vast majority of what we report every day, every week, every month, does not rely on some ironclad promise of confidentiality to a source. So this comes up in the exception rather than the rule. It has become more an issue for us in recent times because, frankly, I believe of the prominent cases that have had so much attention, perhaps even more attention than they deserve, but as a practical matter, these cases have sent a message, like the Scooter Libby case, have sent a powerful message, I think, to private litigants, to prosecutors, and to journalists throughout the country that have really had an effect. Let me tell you what I think those effects are in my impression. Again, perhaps surprisingly, we at ABC News, I will say, do not yet see a reaction on the part of potential sources saying we won't talk to you. At ABC News, the way we're structured is, as a practical matter, we have an investigative unit of several people who do our most sensitive work, and those are the people who are charged with the responsibility of determining when to give out confidential promises. They come up to me, ultimately, through a special senior vice president we have for editorial quality, and we clear them. But we have a limited number of people who do this because you cannot have, we have 1,500 people working at ABC News. You cannot just give everybody blank pieces of paper to go out and give promises all over the place. So we have a limited number of people. When I talk with them, they say they believe at this point that despite what happened, maybe even because of what happened in the Valerie Plame case, that sources continue to believe that we as journalists will go to the mat, as it were, for them. Ironically, they see the 8 months that Judy Miller spent in jail as indicating how far journalists will go to protect them, rather than what I thought would happen, which is, in the end, the source came out. So we do not see sources drying up yet. I'm not saying it won't happen. What I do see is the people that we do have who are doing sensitive investigations are much more reluctant than they were before to give out those promises of confidentiality. So thus far, at least speaking for ABC News as a practical matter, it is more the self-restraint that's come to the fore. We will still do it, but it had better be a very important matter, and we had better be absolutely sure that we are willing to go the extra mile for it before we give out the promise. Let me hasten to say that's not altogether a bad thing. My strong impression is that journalists had fallen into a pattern of being way too easy on saying, okay, it's off the record. Well, what does off the record mean? Does that mean you promise you won't just disclose it voluntarily in your own piece, but you will disclose it if you're subpoenaed? Or does it mean that you'll go farther than that and you'll litigate it all the way up to the Supreme Court? Or in the end, does it mean even if the Supreme Court rules against you, you will be willing to go to jail as an act, as the dean said, of civil disobedience? That we have been far too lax, as a practical matter, in the discipline we should have. And I think that that is self-correcting to a large degree as a practical matter. A lot of the problems we have, when we do have problems at ABC News, do not come up because of the Department of Justice. I mean, I applaud the guidelines that have been in existence since the 70s, right, Chuck? I applaud them. And by and large, we have issues from time to time with prosecutors, with federal prosecutors, but they almost always get worked out behind the scenes. And they get worked out in different ways. I mean, we were threatened with all sorts of things when our investigative unit went and tested the ports, first in New York and then in Los Angeles, and having depleted uranium brought in through to try to show there are problems with the security system. We were threatened with coming into the newsroom and seizing all your documents, things like that. It never happened. It never happened. By the way, my reaction when they said we were going to do this, I said, that's great, just have a camera on it. Just tape the whole thing and put it up on the broadcast. It'll be great TV. On the other hand, when one of my colleagues, John Miller, went in and was the last Western journalist to interview Osama bin Laden in 1997, we got a call from some very senior security people saying, we really want to see the other parts, the outtakes. And we're always very chary about being too close in our cooperation with law enforcement. So what we did is we put it all up on the website and said, great. And that way, and then we just called them up and said, fine, it's all there for you to cooperate. So there are a lot of ways that these things get worked out that never come to light, but as a practical matter. So it's very few times we have real problems with the prosecution, and in the end, particularly in the federal prosecution. That said, where there is a very big problem, again, for ABC News right now, is civil litigants. Civil litigants don't have the same restraint, and they can get into a lawsuit, and subpoena, whether it's really necessary or not, journalists to ask for their confidential sources. And they have perhaps the best of motives and perhaps just a motive to get a big settlement. And they know that a corporation such as mine that has a lot of money may well be willing to write a fairly big check, not because we were wrong, we were absolutely right in the reporting, not because we did anything wrong, but because we want to protect the confidential source. And that is where, as a practical matter, right now we have one pending from Mr. Hatfill, who was reported in much of the media, including our media, as being a person of interest in connection with the anthrax. And our reporting said, you know, there are a lot of doubts about it, a lot of reasons not to suspect him. On the other hand, the FBI is pursuing it. And we have a private suit right now in which they want to know exactly who our confidential sources were, despite the fact, if you go back and look at our reporting, the vast majority of reporting had nothing to do with confidential sources. Everything we did was confirm someplace else and was revealed what it was. But it gives an enormous lever, potentially, to private litigants who are seeking money damages. So from our point of view, practically, that's where a lot more of the problem comes. Now, having said all of that, I will tell you that I believe I know that there are important stories that the American people deserve to know about and need to know about that would not see the light of day without some help from confidential sources. I can tell you from ABC News, I can tell you 3 different ones that I think never would have come to light. One was reporting on problems with the FBI laboratories a few years ago that we were all over, and it wasn't exclusively confidential reporting, but without the confidential reporting, it never would have happened. Another one was reporting on problems with the VA system a few years ago that confidential sources tipped us off to. Now, we went in and confirmed it, including with some undercover work. Again, not relying simply on confidential sources, but that story, which was a terribly important story, never would have seen the light of day without confidential sources. And third, at the state level, some of the Illinois political scandal that involved the bribes for some of the testing for transportation in Illinois that ended up with the indictment of a former governor, as I recall, never would have happened without confidential sources. So I can tell you that even though they are by far the exception rather than the rule, and even though we are tightening down, there are cases that won't see the light of day. Now, net, I agree with what everyone has said about balancing. I mean, we can have a dispute about who should be doing it. And frankly, I think if judges do it, it doesn't mean the Justice Department can't have prosecutorial discretion and still have their guidelines. If there was a federal statute, it doesn't mean that the Department of Justice can't have guidelines. They can still do the fine job they've been doing for all these years, and we would applaud them for doing it. So we can talk about who does the balancing. We can talk about exactly how it gets structured. But the last point I want to make is the big problem we all have, and this is journalists as well as citizens, as well as prosecutors, frankly, is you don't know whether we've gone too far until real damage has been done. We won't know whether we've shut down the sources too much until we have a real problem in this country that didn't get reported. If we had had a confidential source that had information about weapons of mass destruction, we did not, by the way. But if we'd had one that we've been given promises to, it might have changed the course of history in this country. I don't know whether it would have, but it might have done. And those are the sorts of stories that we at least run the risk of foregoing if we strike this balance the wrong way. I believe in balancing, but we have to make darn sure we're getting the balance the right way. And that's all I have to say, and then we can have interactive. Thank you very much.
Well, I had mentioned that we wanted to respond to what was on your mind, so unless you ask questions, we're going to drone on.
That's right. Or go to lunch.
Does anyone have any questions? Thank you, Louis.
David, this is principally for you, but also for Mike. I'm curious to know, without details, David, you've been president of ABC News for 10 years. On how many occasions have you been asked by a senior, unidentified government person not to run a story for national security reasons?
I haven't tallied them. Did everybody hear the question? How many times have I been asked by a senior government person not to run a story? I haven't tallied them up. I will tell you that it's probably not as often as once a month, but several times a year. So it's fairly frequent for a variety of reasons. And we have, I mean, I've learned, I mean, frankly, by mistake to some extent over the years, how to handle these. First of all, we have a standard policy that if we have something that we think may involve national security, and this can be everything from, we believe there's a special forces raid going on in Afghanistan, which was a real story, that we were asked to hold for a period of time until the special forces could get back, and we did. We held it. All the way over to secret detention facilities or prisons in Eastern Europe and Northern Africa, which is another true story. If we have something we have reason to believe raises national security concerns, we must contact the relevant part of the government and ask them, first of all, to find out if it's right. But secondly, even if we're really sure it's right, I want to give the relevant agency an opportunity to make their case to us. And some agencies are wonderful about that. Some agencies are deeply resentful. I've had a principal of a major security agency say, why should we have to come hat in hand to you? And I said, I just think that's the way the Constitution has it. I mean, we get to decide that. But, so first of all, we have to run it past. Secondly, this may be of interest to you, I learned the hard way early on that if there is something they really want us to stop or to delay or to modify substantially, I want the principal of the agency on the phone to me. Because too often it's been the case that, frankly, the Assistant Secretary for Communications, essentially the PR person who has an important job, relevant job, it's easy for them to say, absolutely don't go with the national security. And we've had one or two of those where we went along with the request, and looking back on it, we thought, wait a second, that was not really that serious. So my basic position, if you're going to ask a news organization to hold a story, if it's that important, then it should be important enough for the principal to spend 10 minutes with me on the phone and explain. And I've had some very good discussions, and in response that we have a story right now that we've been holding for 6-8 months that we've been requested to do because, and my conclusion is that there really is a national security issue involved. And weighing against that, it's a really good story. It's going to break my heart if somebody else beats us to it, which is possible. But it's not going to change the fate of the nation. It's not something where elections are going to turn on it, or it's just a really good story. And so we've been sitting on it for 6-8 months now. But it happens several times a year at this point.
And I just want, pardon me, I just wanted to mention that, and I think you heard this in David's remarks, that if news organizations conclude, whether in a very small scale case like a crime victim or the very sort of large scale cases that David's talking about where national security is involved, almost all news organizations, certainly the ones represented here, will exercise restraint. I did this myself just a few weeks ago. There was a new national intelligence estimate about Iraq that came out. And in the classified version of this, the government spells out what its singular fear is about what could occur in Baghdad around, pardon me, it was around the time of the general's testimony. It didn't occur. But it was something that they didn't want to give them ideas, which they felt like my reporting that would. I also felt like sooner or later someone else was going to report that. But as has been the sort of reaction I've had of other places through my career, I just said to myself, that's something we don't need to be first on. Like, that person's relative doesn't need to read that from us. I'm willing to be beaten on that. And I think David will agree that that is more often than not how these decisions are made. Sir.
David, what do you rely on if you had that conversation with the head of the agency and you've gotten an impassioned plea, please don't? At the end of the day, what do you turn to try to make the right decision? Do you have, for instance, anything that resembles the Justice Department guidelines that are applicable to media in making these decisions?
Not written down. I have my own standards. As I say, we have a senior vice president for editorial quality, and she has about 4 or 5 people working for her whose job it is to check and make sure what we're doing is right, but also to set policy and enforce policy. And my guidelines are pretty simple for this, which is it's balancing on the one hand the interests in or the need for the public to know, and on the other hand, what is really the national security concern. And obviously that's pretty general, but I don't know how much more specific you can make in that. And then a third element is, even if there is a need for people to know, and even if I'm not convinced that the national security will really turn on this, how much do people need to know? In the secret detention facility story, for example, after discussion with a principal involved, I decided that while it was important for the American people to know that this activity was going on, they did not need to know the name of the countries, which we had. And that was simply because part of the claim was if you name the country, that country will never cooperate with us again. It seemed to me it made sense for the American people to know in general their government is doing this, and they can decide whether they like that or they don't like that, and it's important for them to know that. But whether it's this country A or country B is not going to make a difference in people's minds. And similarly, there's a timing issue sometimes when we will go and they'll say, hold it, and I'll say for how long, and they'll say forever, and I say, that's too long. You know, let's back up from forever. But for a reasonable period of time, I'm willing to give them the benefit of the doubt. But as a practical matter, I must say, I've been through quite a few of these now. The answers to me are usually pretty clear. They're not that hard. I mean, when somebody says, we have troops in the field right now, and if you give us 3 hours, we can get them back safely. The American people don't need to know during those 3 hours that the troops are in the field. And it makes sense to me. I mean, I don't think that the Taliban is monitoring ABC News. I mean, that would be very flattering to us, but I don't think so. But it could be. I can't rule out that possibility. So that's pretty simple. On the other hand, I had a principal at one point say, oh no, but what you're doing is you're giving ammunition to forces in foreign governments who are opposed to us to say that we're not a good government. So that it gives them more political power within their parliament. And I said, well, wait a second. If that's the rule, we shouldn't be reporting half of what we report. If anything we report that could be used for political purposes somewhere to criticize us, and in fairness to the individual, once they made the point, and I responded, I said, yeah, okay, fair point, you're right. But so it's usually surprisingly pretty clear.
Also, when you ask a principal, as David explained, to explain to you why they're making this request, oftentimes in their floundering effort to make that case, they will realize themselves why you're reporting it. And they usually won't tell you that they're right, that you're right, but they also will understand the decision that your news organization makes.
Let me add one thing, though. I still see things in the paper, not every day, not even every week, but regularly, that stun me. And I don't know if these are things on which a principal went to David or Mike or to Mike's editor and asked them to withhold publication. Maybe they did and they were turned down. Maybe they never made the request. Just because, though, that some things are classified doesn't mean that everything the government seeks to keep classified is improperly classified. And with all due respect to David and Mike, I don't even have the context, knowing the information, to know whether or not its disclosure will ultimately hurt us in some way. Some of those things aren't known for years, or I don't know the full program. I may only have a little piece of it, and many people in government will have little pieces of it. And so what particularly galls me is the claim that, you know, we've weighed the request from the principal. It seems like something we could probably report about. We think we understand the context for it, and therefore we launch.
Right.
Now, we have cried wolf too often as a government, and I believe we've overclassified lots of information for the reason that Jim Comey so eloquently explained. It's easier. But that doesn't mean there aren't true secrets that ought to be kept secret, and I still read about them in the paper. So
I couldn't agree more, and it is a deeply imperfect system. The question is what the alternative to it is. Right. You're absolutely right. I mean, it's part of the reason why in a different context of the First Amendment, a famous justice once created the clear and imminent danger rule, so that it can't be too attenuated, because it's like the butterfly that gets crushed and you don't know what happens 3 generations down. Right. It is very imperfect, and we are not the best arbiters in many respects. On the other hand, the alternative is saying to the government, you get to decide. And if you go back through history, the history of this country particularly, I think you would find more instances where the government was overly secretive to the country, forget the press, to the country's detriment, right, than you would instances where the press published things that really caused substantial damage to the national security. I just am reading right now Matt Moynihan's book, Secrecy. I don't know if you've run across it. It's a very good book written in the late 90s. And one of the points he makes is because there was a classification on the fact that the United States had broken the Soviet codes during World War II, while we were supposedly their allies. They were so secretive they didn't even tell Truman. But one of the consequences of that, ironically, was that on the one hand, McCarthy went way too far in saying who was a communist, and there was a backlash saying there really aren't any communists at all. That's not really a threat. And so that secrecy actually hurt us both ways, at least is Moynihan's thesis. And I'm worried that too often in history, we've erred too much on the secrecy side to the detriment, ironically, of our national security.
Fair point. Sir.
Mr. Wesson, you had mentioned before, made reference as to who should be in charge of conducting the balancing test. If not federal judges, who do you think should be conducting the
No, I think it should be federal judges. I mean, I think it's judges in the 49 states and the District of Columbia. It's an imperfect system. And I think, and there are problems, Jim Comey pointed them out, he's absolutely right, there are problems with judges, but ultimately, the judge, to my way of thinking, is the most neutral. We in the press are always going to think we should win. And our prosecutors, bless them, believe in what they're doing and are really eager to do what they do so well. And as a citizen, I am indebted to them for what they do, but they're always going to have their thumb psychologically on the scale a little bit. And so, as imperfect as it is, I would leave it up to judges.
I think it raises an additional problem, though. When we testified before the Senate Judiciary Committee in October of 2005, the proposal at the time had an exception. There would be a privilege, there would be a shield, except if we could demonstrate imminent harm to national security. And there was another section of the bill that talked about a covered person, the problem of defining who and what is a journalist in a journalistic organization. If you throw this whole thing out to the courts, you might have somebody who is a covered person in the 11th Circuit, but not the 3rd. You might have a definition of imminent harm to national security that pierces the privilege in the 4th Circuit, but not the 6th. In other words, I think you're creating chaos where we only have limited chaos. In other words, we have a set of standards that we apply nationally. David's point would be you could still apply them.
Yeah, why not?
Well,
they're good standards.
Because they are good standards, and they tend to work, except that in the end, the final arbiter now will be the courts. And I think you're going to end up with very different law in very different parts of the country.
Well, my response to that is twofold. One is, that is why we have the Supreme Court, to reconcile differences between the circuits. That's one of the main reasons the Supreme Court takes cases. But beyond that, if you talk about confusion within the circuits right now, we've got way more confusion than we would have if we at least had a statute to apply. I mean, the Second Circuit and the D.C. Circuit are on opposite wavelengths right now. They're not close to uniform in their approach.
I'm going to be very parochial here, in the sense that there is not a lot of confusion in the context of a good faith criminal grand jury investigation.
Because of the Justice Department.
Because of the Justice Department and because of Branzburg. In other words, much of the confusion has arisen in state litigation and on the civil side between private litigants.
Right.
With respect to what I do and what my prosecutors do, it's pretty clear that if you're conducting a good faith criminal grand jury investigation, there is no privilege. So you see a lot more confusion than I do.
Right, exactly, yeah. But that's what I said. In general, I mean, the times that we've had problems with federal prosecutors, I can't even number on one hand. I just can't remember problems with federal prosecutors.
Especially present company.
Thank you.
But even the Southern District is not bad.
Yes.
We start direct this to Mike, maybe David wants to comment on it. It seems to me the rise of the blogosphere as a source of news has to do with the fact that people felt that they were misled in the run-up to the war and in the initial months and years of the war. Does that lead you to see your role as somewhat different than that of traditional news gatherers now? And if so, in what respect? And then to David, so if he tells you he's thinking about it differently, are you guys not thinking about it differently?
I'll let David go first.
No, you're at Politico.com. You're the new world.
Yeah, our news organization is an interesting hybrid. It started in January, and it exists primarily on the web, but also has a newspaper version that comes out 3 times a week when Congress is in session. And I went to a blogging conference, the Yearly Coast Convention in Chicago, which some of you are familiar with. And of course, there we were completely MSM. I was put on a panel to, I was put on a panel to defend the mainstream media, so-called, against 4,000 bloggers. And they were all angry. You don't go to Yearly Coast if you're not angry. And they're going to see this, and now I'm going to get in trouble in the blogosphere again. But I liked their passion, and as I alluded to earlier, they're extremely knowledgeable people out there working on blogs. One thing that's that's interesting about it is it sort of reflects the sort of blue and red divisions that we have in our politics. It was a great revelation to me to discover that when a liberal refers to the blogosphere, they're talking about their blogosphere. And similarly, on the right wing looks at it the same way. Now, one point that I made to the bloggers, which they did not buy at all, is that this is becoming a less and less useful distinction. That people who work for ABC News or people who work for the Politico blog, and they either give slices of life or their evolving story. David's investigative unit runs one of the most worthwhile blogs, if you want to call it that, or serial reporting that exists on the internet. And bloggers are being paid to work for Time Magazine and The Atlantic and other newspapers. So I think the difference really is in the intention or the motivation. David's employees, us, are out to find out what's happening, the search for truth that Dean Smolla talked about as we began, whereas what the people who refer to themselves as bloggers are out to project, promote a point of view. But the fact that they are out there, I have found is very valuable to what we do. And one way that you've seen this occur is with the site Talking Points Memo, which has a is an extremely loyal following, and it was their readers who, in various cities of the country, discovered local stories about U.S. attorneys being fired, and no one had connected the dots among those before the blogosphere started doing it. So it has its uses. Where it can be damaging is the sort of assumption that things are being done for the worst motives, and you go on there and you don't recognize yourself at all. And now I've realized how my subjects have felt all these years.
Representing the mainstream media, I guess here, I think there are two critical distinctions for me when you talk about the blogosphere, because different people mean different things about it. One is opinion versus fact. Are you giving me your opinion, or are you telling me what you think is true because it's true? There's a long-standing tradition in this country of opinion journalism, and we have editorial pages, we have op-ed pages, and it's terrific. But historically, at least the best newspapers have drawn a firm distinction. So you know that's what's on the front page is because somebody believes it's really true and it's been checked out, whereas the editorial page might be a different matter. So one thing is, let's make sure, from our point of view at least, that we're letting you know this is somebody's opinion, or yes, we believe this to be true. That's one distinction. The other is, do you have an editor or not? I mean, I personally believe that critical to journalism is having an editor. We all need editors, in my view, because no matter how good we are and no matter how right we think we are, someone needs to check us. And so we believe that there's a place, even in the new .com world, for somebody who's trying to get it right and report what's true, and that has editors and checks things out. So that even the blotter that we have, thank you for referring to it, for the investigative unit, that's all vetted through our standards of practice and things. So we don't just let somebody get on the blotter and say whatever they think. Now, that said, I think that the new world offers a huge opportunity that no one, I think, is fully tapped into yet, which is a sense of community when it comes to journalism, because people out there have something to contribute to the stories that we report, and not just their opinions. They know things about what we're reporting on. And to create a world in which people can contribute and that can become part of the reporting after it's vetted is an extremely valuable thing. And I personally think that's an exciting direction for journalism to go in. Having said that, it's 1,000 flowers blooming. I mean, there's plenty of room for everyone. And the question for us at ABC News is there enough of a demand remaining for a group of people who are really trying their best to get it right and tell you things you don't know about?
And I just wanted to mention one thing that was implicit in your question is that part of the rise of the popularity, both for the bloggers and the participants, and I learned the lingo, the term escapes me at this moment, but a lot of the reason for that was frustration with, you talked about the perceived inadequacies of the legacy news organizations during the run-up to the war. And it's a challenge to us, both as a journalistic matter and as a business matter, frankly, to address that and be sure that we are being as aggressive as they would be, that we would not just spell out 2 and 2, but we would add that and tell them that it's 4. The difference between us is they can take 2 and 2 and make it 5. But at the very least, we need to take 2 and 2 and say that it's 4 and point out when the government is trying to say it's 5.
A question from Mr. Comey.
This is for the blue-collar mic. As a non-elite citizen, I read with interest that what appears to be a change in the language that journalists are inserting to describe why confidentiality was granted. 2 years ago, there seemed to be a lot of rigor, and now I read it was granted confidentiality because they requested confidentiality. Do you see the same thing, and what does that reflect?
Now, that's a great question, and for those of you who read the Washington Post, New York Times, Politico, ABC, the news organizations with the highest standards are asking their reporters to spell out why a source was granted confidentiality as opposed to asking for it, but we decided in the way that David talked about to give them confidentiality. And there's a couple of reasons for that. An important one is transparency for our readers who are distrustful of these sources. I think readers are mistaken in that because quite frankly, quite often, the information, the insights that you're able to get anonymously are more accurate, closer to what's true, more honest than what the person would say on camera. But it's just a fact that people don't trust them. So part of it is that reason. And second is discipline for reporters, that you are not, as David talked about, he's encouraging his people not to do, requiring his people not to do, just sort of automatically doing this. Now, this has resulted in some verbal gymnastics that occasionally are kind of humorous. My favorite one in the New York Times, one of my favorite reporters, Elizabeth Buehmiller, I believe it was, had someone who was quoted talking about the Bush-Cheney campaign, and it said, who insisted on anonymity because he did not want to be called by every reporter in town. And that was probably an honest reason. But the problem is that usually the reason is that who spoke on condition of anonymity because they wouldn't talk to me unless they were anonymous, because they would lose their job, because they would look bad. Like, those are usually the real reasons. And so we try to describe that on a euphemism, either from our side or their side, that sometimes winds up defeating the exercise. What news organizations are trying to do that I think is very useful, we enforce it, the New York Times, some of the best papers are enforcing it, is trying to describe the motive of the person. What side in an argument are they on? Something the New York Times is very good about doing, and we're trying to be better about doing, is with the campaigns specifying when something came from a Republican opponent or a Democratic opponent. There's so much space, both chronologically and bandwidth-wise, in the 2008 campaign that a lot of what's being done is one campaign giving you bad quotes, bad facts, bad videos about another. And these have had real consequence in this campaign. And it used to be we would just use the information and pretend that we had suddenly found a video from like 1992. We're trying not to do that anymore. So what I would say is that often the definitions have gotten sloppy because the reporters didn't take it seriously or knew that it wasn't really being fair. And I think that's a challenge to us to tighten it up and try and tell our readers and viewers and clickers where our stuff is coming from.
Sir.
David and Mike, in the first panel it was mentioned that it's not entirely clear what's being promised, promised source anonymity. And I think you reiterated that, David, in your remarks. As a practical matter, today, if that promise is being made by one of the organizations, what do you think you're promising? What do you think your source understands?
Well, I believe that we're being much more precise than we were before, and I assume other news organizations are. As I said, there's a range of possible promises, everything from we won't mention your name in our piece to we'll resist to the so-called go to jail promise, which is the most extraordinary one to make. So I think it depends. I personally believe, now this may be just Pollyanna on my part, I personally believe that if there were a federal statute, it might help some of the regularity to really make people focus on what is being promised and in what circumstances. Because courts presumably would ask the reporter exactly what did you promise? What language did you use? what exactly was said? Is there anything in writing? Questions like that to give some regularity. Right now, I find it amorphous.
Do you have anything in writing?
We do not do confidential pledges in writing, no.
Well, what we've gotten better at is being explicit about the terms on which we're speaking. One of the speakers, perhaps David was talking earlier about, off the record can be vague. I think all of our news organizations now are very specific about saying, all right, this information will not be used at all. This information will not be used at all, and I will not go and check it elsewhere. I will call you a Republican. I will call you a senior administration official. I will call you a White House official. I will call you male. I will call you female. What is a practical matter, because these are human interactions, is, David, tell me if I'm wrong, but it's rarer that you will specify, okay, I will go to jail till this is appealed to the circuit court, or exactly what it is. But the only reason someone speaks to me is because they trust me, they trust my news organization, they trust my track record, they trust what I will do with that information. And I think implicit in that is that I will protect them, and with a sort of sense of infinity. Now, in this recent case, we got a sense of the fact that infinity can be very real. But I think people talk to us because they know that we're going to protect them extremely zealously.
Well, let me add something, though. And you probably know this, but maybe you don't think about it. We use confidential sources, too, all the time. We do them in our sensitive investigations. We do them in our routine drug investigations. But our FBI agents and our DEA agents don't make promises that the law would not permit them to keep. One of the ironies here, I mean, if a DEA agent recruits a source who gets us into a big heroin conspiracy, that agent may tell the source, I will do everything in my power to make sure that your name never surfaces. And there's Supreme Court jurisprudence that talks about a balancing test and when it might have to be revealed and when it can be kept confidential. But no agent is going to say, I will go to jail before I give up my source. The law simply doesn't permit us to do that. And so I think one of the ironies here is that journalists, in very rare occasions, are making promises that the law does not recognize. And I think that's a fundamental problem.
Well, as was said earlier, I think Dean said it, it's an act of civil disobedience. It's someone, if it's gone up to the Supreme Court and the Supreme Court's decide, there's a binding court order, and you're right.
But imagine if an FBI agent committed an act of civil disobedience. Imagine if that agent said, I know what the law requires and I understand my oath as an agent, but I'm not going to do it because I have a greater good here, and I've decided that for myself. I don't know that either of your organizations would take very kindly to us if we did that.
Well, but that's one of the phenomena of civil disobedience. You can be civilly disobedient, and you're fully open to whatever criticism in the marketplace of ideas there might be.
Correct.
And absolutely right, whether it's us or someone else. I mean, we can be criticized as well.
I'm just wondering what the coverage would look like if we did it.
Well, I think it depends on the circumstances, actually.
Yeah.
Would each of you offer reflections or lessons learned, if any, from the Valerie Plame saga as it has played out?
Well, so despite the fact that this might come back and haunt me, I'll tell you, just to be pragmatic, this is not legal, but just pragmatic, I take two principal lessons away from it. Number one is, if you're going to fight Armageddon, make sure it's on a ground that you really need to fight Armageddon about. It's one thing if it's Pentagon Papers, it's one thing if it's Watergate, it's one thing if it's going to change the fate of the nation. But you've got to be very careful about where you're fighting those big battles. Because if you look at it at the outside, and frankly, if you do a balancing test the way I would envision it, someone behind the scenes, this is not you now, this is in the journalism community, would quickly ask, wait a second, what are the stakes really ultimately in this case? Really, what good was done by this reporting, or even not reporting, that was happening? So that's number one. And number two, and this will sound a little cynical, but it's pragmatic. If you're going to cave early and cave really quietly, because you're not doing anybody any good to go out with all your flags flying high and drag this thing out for the reasons I suggested earlier, because you're sending a message to litigants out there, whether they're government litigants or private litigants, that say it's now going to be an open season on journalists. Even if that's not really what the case says, people are not that subtle in the messages they take. And you can do a lot of damage behind the scenes in the way people think about things. So I mean, if you can take care of this quietly behind the scenes, and that's where you're going to end up anyway, do it quickly.
And to be even more practical about it, and this is something that I've talked to our young reporters about, is it taught you how important it is that what you're doing would look appropriate and sensible if it was exposed to public view. Mr. Comey talked earlier about the New York Times rule, the Washington Post rule. It's no different from us. It is not an unreasonable question to ask as part of making a journalistic or ethical decision. How would this look if this were written on the front page of the New York Times? If my readers and my bosses knew that I was referring to Scooter Libby as a former congressional official, would they really think that that was kosher? And I think journalists may have gotten into, and I do not subscribe to this, and I insist that our young reporters don't either, but I think reporters sometimes allow themselves to be sloppy and say, well, sausage making isn't pretty, just like it is in politics, like I sort of did what I need to do. That is not an acceptable way to do the job. And in the Libby case, we saw some of the consequences of that.
I've drawn a much more narrow lesson from the case. Simply that Pat Fitzgerald is the best federal prosecutor in the United States. When I grow up, I'd like to be just like him. So. Yeah.
My first question is to Mike and David. In your mind, when your organization or you personally grants confidentiality to a source, who do you think the privilege belongs to you or to the source? And then to Chuck, what happens in times of a waiver when somebody says, okay, like we saw in the Libby case, we've gotten waivers from everybody. So now do you, if somebody comes to you and says, we have a waiver, what goes on in your mind? Does that mean I'm free to tell now? Or are you even concerned about possibility of coercion?
That's a question for a boss or a lawyer, and David is both.
No. I mean, the question of who it belongs to, for me, apart from the legalities of it, the real question is who can waive it. That's the real effect of that for me. And for me, if the source waives it, then it's waived. I mean, I can't imagine us saying, no, we're still going to keep the confidential, even though the source is saying they'll waive it. Now, coercion's always an issue. I mean, that's true in every waiver situation, and you're going to have to make your best determination, is it really a meaningful waiver or not? But if the source is waiving, then I don't think that, I can't imagine just sitting here right now what ground we would have to say, no, we're still not going to tell you, court or prosecutor, even though the source has come forward.
Yeah, I agree. I believe it belongs to the source. As I mentioned earlier, the attorney-client privilege belongs to the client, and the priest-penitent privilege belongs to the penitent. So I think the same analysis would have to apply.
I mean, there's a different set of issues about akin to work product. When you have, behind-the-scenes journalistic, editing, that goes into the mindset of the editing and things, but that's different from a source issue. I mean, there are issues involved when you want to come in and get all the notes that went into the piece and what you left in and what you put out. You can argue about a work product that would belong to the journalist, but that's not this.
Although I should add that when we're talking about government sources, the privilege belongs to us.
Did we get at what you were asking? I want to be sure we answered it. Okay.
Yes, ma'am.
My question is for Chuck, and I just want to push you to explore a little bit your belief that an act of civil disobedience would not be appropriate for someone within the executive branch or the law enforcement side, because it seems like that is a problem within our culture. It's not just Nuremberg where people had that viewpoint. I think also at Abu Ghraib, I think that there are cases where a member of the executive branch, there is a higher good, where we need to have there would be an option for civil disobedience that would be more patriotic than simply sticking to the rules. And would you not agree with that?
I accept your hypothetical. I believe you could conjure up, and I don't mean that in a derogatory sort of way, but I believe you could have a set of facts where a good, decent, hardworking public servant couldn't execute an order or couldn't do what was asked of her. Fair enough. It was not entirely hypothetical in my experience, and I think you really have two choices as a public servant, putting aside the exceptional case, which is to execute the order or to resign. But I have a hard time in my more routine example imagining that an FBI agent could engage in an act of civil disobedience simply because they didn't want to disclose the name of a source. Your example is a fair one, and it's a much more difficult question. The way I would answer it is that I would either obey the executive order or resign. And frankly, I'd be very happy to resign if I didn't believe I could or should obey the executive order. It's always that option is always open to me.
Well, just taking Abu Ghraib, since it is the extreme example, but one that's real. The photos were taken on just a little disposable camera. And if that had been mailed to an FBI agent who came to you and said, they must, or it wasn't mailed, but a description, they're requiring that their name isn't used in order to break the story, something very important.
The agent is requiring that his name not be used? I'm not.
No, the source. I mean, it came from someone found the pictures taken by some private, right? And what would you do in that case? Just tell the agent that they should resign rather than keep the source confidential if it came down to it?
No, I mean, we have lots of ways to get information, and we can compel people to give us information. In that case, we would conduct a routine investigation, and we could put people in the grand jury, and if they asserted a Fifth Amendment privilege, we could immunize them and compel them to give us evidence in that case. So no, I don't think it reaches the problem you're describing. I think the more difficult question is whether an executive or branch official can ever engage in an act of civil disobedience. And being a creature of the law, I have a hard time getting my small brain around that. But again, I think there is an option open to me. And if I was ever asked to do something I couldn't do, I would resign. Let me add something to that, though. You know, there are a whole other set of protections for people who see things, hear things, read things that are illegal or disturbing or raise questions about the propriety of an underlying act. We have a whole set of whistleblower protection built into the law. I'm not an expert here, but you don't just have one route to David or Mike. Okay? You can invoke the whistleblower protections and disclose something that you see that you believe is illegal or improper in a lawful, appropriate form, in a way recognized by law. So, you know, I think we have to get away from the notion that all leaks serve some public policy purpose, or all leaks are good and beneficial to the body politic. I think most leaks are, many leaks are venal or malicious or self-serving or crimes in and of themselves. And so you have options. If you're an executive branch official, you can go whistleblower protection or you can resign. It's not like your only option is one of civil disobedience.
And I agree that many leaks, just like many sources, are venal or self-serving or malicious, as you said. The difficulty is not every leak from bad motives fails to lead to a good story. I mean, a lot of our sources, including in law enforcement, a lot of your sources, I presume, are not wonderful, upstanding citizens. They're people who've been involved in or seen or...
They're criminals.
A lot of them, exactly. But the problem we have is we don't have the luxury of just saying we're only going to deal with nice people, you know, and people who are pure of heart. But we do have the obligation to try to figure out what the motive is, and that goes to Jim's point about trying to reveal why the confidential source didn't want their name revealed, because the audience ought to be able to assess themselves, should I believe this or not, based on the motive. But agreeing entirely that most leaks have not altruistic motives, that doesn't tell you whether it's good for the body politic to have the leak.
And I agree, but I guess my major point is that there's another route. In other words, you don't only have the media as an outlet. You can go whistleblower protection. And again, somebody who knows more about it than me would have to explain how that works. Sir.
When it comes to national security and you have a leak in the executive department, how often do you contact the minority party to see whether or not they feel that it would be a risk to divulging it? And if there is a consensus between both sides of the government, do you weigh that in heavily?
No, I think it's to you.
No, it's
Your
to
government.
Mr. West and Mr. Allen.
Yeah. To the minority party?
Right, like for
If
example,
the leak comes from a Republican source, do we go to the Democrats and ask them if it's okay to reveal it?
when they leaked the wiretapping, for example, both the Democrats in Congress and the executive asked them not to release it. How much does it play in what the other side has to say?
I see. Was it wire? You mean the National Security Agency program? Is that what you're talking
Both
about?
factions of government asked you not to say. How's that?
I think what you're saying is that if both sides agree that something should not be disclosed, does that influence their decision to
I'd certainly
publish?
take it into account. I mean, if it's a foreign affairs thing and Senator Lugar called up and said, I've heard about this and I have to agree that we shouldn't be doing this, or I would pay attention to that. So I must say that's never happened to me. I've never had that experience, but I would certainly take into account if they're knowledgeable people, who know about this area and have expertise and have the best interest of the country at heart. I'd have to listen to them, absolutely.
Yeah, and I think that's part of the reason that David said that he'll often press to have a principal talk to him, is that when he's making those decisions, you want all the information possible. So if that person had more information, that would be valuable to the decision-making process.
Sir.
I kind of have a question along those lines. Do you wait for Senator Lugar to call you up? Or, I mean, if you have something that you think might be a national security issue, would it be incumbent on you to go and, seek the government's opinion on this? Or if they don't find out about it, would you run with the story?
No, I tried to say that earlier, but probably wasn't clear enough. If we have something that we have any reason to believe might implicate national security, we go, now, typically, it's not a congressional issue, it's an executive branch issue, and we go literally to the CIA, to the FBI, to the Department of Homeland Security, to the Justice Department, or to the White House, and go and say, look, we have this story, we believe it's sound, we want your comment on it. Partly to make sure we've got it right, or to see if there's some comment or something that we didn't understand, or there's a further aspect to it that would change the story. But also, quite specifically, partly so that they can have an opportunity to say, wait a second. And typically what they say is, we won't confirm or deny. A few times they'll say, yeah, you got it right. But normally they say, we can't confirm that or deny it. But let me explain to you why it's going to be really bad for you to go ahead with that story. And then we have the discussion. But we, as a matter of policy, always go to what we identify as the relevant government agency. And if they send us to another one, we'll go to that one. Because the last thing I want to do is do something bad in any context, but particularly when it involves national security, without even knowing I'm doing it. At least let me know what the dangers are, so I can make some sort of informed choice. The worst thing I can do is inadvertently tip the government's hand to bad people.
And a related point, like one of my sort of rules of thumb is, like, whatever someone is going to say in front of cameras the day after the story, you want them to say it to you the day before.
Right.
Maybe you'll put it in, maybe you won't, but you want to know what it is.
Maybe it.
Well, take one last question.
Mr. West, Mr. Allen, do you have stories that you regret either not publishing at the time or publishing at the time?
I'm sorry.
Do you have stories that you wish you had published at the time?
I'll tell you an anecdote, but it's of no great moment. I mean, it didn't matter. It's a little competitive thing. The first tape that came out of the so-called American Al-Qaeda, this young fellow from California whose name I've forgotten right now.
American Taliban.
Dadan. Yeah, exactly. We got that tape through sources in Pakistan. And we gave a copy of the tape to the FBI to confirm that, in fact, this fellow was who he purported to be, in part to confirm it. And they said, we think it is, but let us have a couple days to verify. And about 2 or 3 days later, it showed up on Fox News. And later we found out it was not the FBI's fault, by the way. Someone in the FBI gave it to somebody on the political side outside the FBI. And the FBI felt terrible about it and was very apologetic. But in fact, somebody on the political side had given it to Fox News. So it's an example. Did people look at me and say, aren't you an idiot for not going with it? Sure, there was some, but it's just a competitive thing. It didn't affect the future of the country by any means. So I regret it in that sense. No, the big regrets are what was raised earlier. It's weapons of mass destruction. It's things like that, which was not something that we had and didn't go with. We just didn't press hard enough, and we weren't skeptical enough, and we didn't ask enough tough questions. And I do think in various ways, having nothing to do with the blogosphere, I think that a lot of us are still suffering the after effects of that. It's affected us because we feel that we let the American people down. And I'm not saying whether we would have gone as a country into Iraq or not. That's not our decision to make. But the American people should have known more than they did when the decisions were made, and that's our job. That's really what our job is.
There's a quick point about that, is sort of subset of the weapons of mass destruction issue, and that is, this gets back to us being Branzburg, not Kurtz, that we don't always recognize the significance of things at the time. This is the Bob Woodward idea that Watergate emerged not from a big front page Sunday story. Watergate emerged from hundreds of, like, literally this size story inside the paper. And as you all know, there were bits of evidence related to the mass destruction that appeared on David's Air and in our newspaper, but they didn't. We didn't connect the dots in the way that we should have. So the only regret would be overlooking a piece of the puzzle. The very smallest thing we can do is make sure all the puzzle pieces are on the table. It's up to others sometimes to assemble that puzzle.
Well, let me just say, only because I'm sitting in the middle and for no other good reason, what a privilege it is to be here and to use this occasion to reflect on an extraordinary man, Justice Powell, and to be here with Louis and Joe and their families. It really is humbling. I didn't have the privilege, as David did, of knowing him or working for him, but I wish I had. And this is such an important, I believe, debate, conversation to have, and it doesn't end today. It'll go on for another 100 years at least, but thank you for letting us be a part of the celebration in memory of your father.
Well said.
Indeed.
You're here. Thank you.
Thank you, David.
Up next on C-SPAN 2, presidential candidate John Edwards talks about his health care plan. Then, in about an hour, members of the Little Rock Nine mark the